indulgence, my lord. Item number 5, my lord.
Yes,
Yesterday, I have tried to contact the engaged advocate appearing on behalf of the respondent, my lord, but I could not find out. But due to some, in this case, I am led by senior advocate Mr. A.M. Bora. But due to personal difficulty, can it be adjourned today, my lord?
no mention memo, nothing.
My lord, I have tried yesterday, but did not find any of the engaged counsel, my lord, the respondent.
Yes, Buyan or Jahan, whoever.
I did.
On request made on behalf of Mr. A.M. Bora, the senior counsel for the appellant, list the matter after 2 weeks.
May I please, Lordship?
Yes.
Item number 11, Lordship. In this case, Lordship, I have filed an additional affidavit for the appellant number 2, but that was not tagged with the record, Lordship. Any date in there, can it be on 25th of May, Lordship?
Additional affidavit in the criminal appeal or in the I?
Criminal appeal, Lordship. I has been disposed of, Lordship. Actually, I is filed for early listing, Lordship. So that is disposed of, Lordship. For early hearing, I have filed that I, Lordship. Can you give it 25th of May,
Dear
Lordship?
Mr.
A. Sharma.
Mr. A. Sharma, the counsel for the appellant submits that he has filed an additional affidavit in the main criminal appeal. Stop. When did you file it?
2-3 days back, Lordship.
Stop. Register to verify and place the same on report. And list the matter after 2 weeks.
Can it be on 25th of May, Lordship?
I can't fix a date. You are doing the.
Oblige.
May I please?
Yes,
My lord, I victim item number 4, my lord.
yes.
My lord, this may be taken up. So, weeks, my lord.
On request made by Mr. R. Ali.
Lordship,
then the
Lord.
counsel for appellant. List the matter after 2 weeks.
Item number 8 also similar prayer.
8 goes with 9,
Yes.
isn't it?
Oh, my lord, 9 may not be, my lord.
I 8.
Because, my lord, I may pray for bail also. Let my reach the matter,
So,
my lord.
item 8,
8.
8, 9, all are connected.
all are
This is
connected.
that Jhankar matter for 10 rupees for a boy was killed at Karbi Anglong, Difu, by the auto.
8 and 9, all
My
are.
lord, I know, my lord, but 9, my lord, matter maybe reach, my lord, because I have to say something, my lord, because, my lord, I may pray for bail also, my lord, because bail petition is pending in the appeal, my lord. If appeal is required, take time in hearing, my lord.
When do you want it?
8 after 2 weeks, my lord.
Then we'll give you a fixed date, Mr. Sarania, instead of taking it piecemeal.
They are the same accused, same
Give you a-
offense.
Yeah, same offense. Instead of taking it up piecemeal.
But my lord may not be, this is
I'll
right
give
time,
you a
my lord,
fi-
not
I'll-
if
I'll give you
302,
a
my
fi-
lord,
I'll-
unnecessary when behind the bar, my lord.
I'll give you a fixed date. Considering that you have some urgency.
Not a case of
Today-
302, my lord.
No, today he's praying for bail. And these are all connected matters. If we take up piecemeal, we'll have some difficulty.
Other penal provisions, we have already suffered, my lord. The rest are will be illegal if it is, my lord.
And I think the lower court records are also not here. It's in the section. It's written in the cause list.
You are appealing on behalf of?
And A Sudhari, man. Item number 8, man.
On request made on behalf of A. Chowdhury, Learned Counsel for the appellant in Criminal Appeal 135 of 2020. List the matter again on. After how many days you want?
2 after 2 weeks, man.
Paperwork maybe too.
1st June.
My lord.
My
Paperwork
lord,
are ready.
my debt may be recorded, my lord, that my part, my lord. Because it will go together. Otherwise, I'll be in trouble with before my clients, my lord. So,
Selected, praise for adjournment for 2 weeks. Huh? Same is objected to by Mr. M. Saraja, Learned Counsel for the appellant. In item number, in
9.
Criminal Appeal 136 of 2020. However, in the interest of justice, adjournment is allowed. List the matter on 1st June.
My lord, I am for the
Hello.
involvement in the both the cases.
Okay. You are Mr.
A.K. Hussain.
Mr. A.Q. Hussain, Learned Counsel for appears on behalf of the respondent.
Paper books are ready. I don't know why the LCR is kept in the section. Perhaps it's bulky or
Bulky. Because of
Perhaps. Lodged. After 2 weeks, our lordship will give a fixed date.
I'm giving a fixed date on first June,
In both the cases, madam,
both cases.
I am available.
Please, Your Lordship, I beg to mention item number 3, Lordship.
Yes.
It is a fully
Seek for an adjournment, Lordship.
On request on behalf of Mr. Aaron Boyd.
After 3 weeks,
Letter after 3 weeks.
highly obliged.
May I please your lordship? I beg to mention item number 10 lordship. Kindly list the matter after a week lordship.
Item?
10. 10 lordship.
We are appearing on behalf of,
BM Chaudhary lordship.
on request made on behalf of Mr. BM Javed and the council for appeal. List the matter after 2 weeks, 3 weeks,
2 weeks lordship.
after 2 weeks.
Obliged lordship.
May I please your lordship, I beg to mention item number 2, lordship. Lordship, may be
No
adjourned for
mention
the day.
memo, no mention memo here.
Lordship, actually, due to some personal issues, lordship, I'm on behalf of A Jammu, lordship.
Yes, we are,
You did not inform us
that's
beforehand.
the whole thing.
Lordship.
And the lease is getting exhausted. On request made on behalf of Mr. A. Jamal and the council for the appeal. List the matter after
1 week, lordship.
2 weeks.
Obliged, lordship.
Lordship, I'm praying for adjournment, Lordship, which is listed for tomorrow, Lordship, item number 4 of daily list.
Tomorrow,
Tomorrow, Lordship, on
that
7.
you mention tomorrow.
Lordship, I will not be available to tomorrow, Lordship, that's why. And
You get someone
adjournment request I have prepared, Lordship.
that you prepare and submit it.
Lordship,
Let somebody mention.
Lordship, obliged, Lordship.
I can't have a adjournment.
May I please your lordship, lordship, I beg to mention item number 6, lordship.
Yes.
With the consent of the other side, lordship.
Oh,
Uh,
you are putting on behalf of
appellant, lordship. For seeking adjournment,
your
lordship.
good name
IU Chaudhary, lordship.
on request made by you to appeal on the council for appeal. List the matter after
3 weeks, lordship.
2 weeks.
Obliged, lordship.
Item 1 of the hearing.
Huh?
May it please your lordship. Lordship, this appeal is preferred from jail by the appellant against conviction, lordship. The appellant has been convicted under section 302, Redu 201, and has been sentenced to suffer imprisonment for life, lordship. Whatever in this case, lordship, there are 8 PW examined by the prosecution during trial, lordship. And among them, PW 1 to 4 have claimed to be the eyewitness of the occurrence, lordship. PW 1 to 4.
Court master. What is your paper book is okay? Yes. You can come here in front to it. Oops, there I am. Oh, upside down. My paper book is all upside down.
Upside down.
My paper book is okay.
Even my brother's paper book is okay,
Okay.
except mine.
Lordship can take mine.
No,
Lordship.
no. We'll have it day after tomorrow. We'll have it day after tomorrow. Let them arrange the.
There are eyewitnesses here.
Your good time, please.
And Hassan Letter.
Heard Emma and Hassan Leonard. I also heard MSS down Leonard.
He wants to do it today.
You want to do it today?
Lordship, may kindly take up that paper book.
Problem is my paper book.
I can hand it over. Perhaps I
This is
have
in
not
order,
written
Lordship.
anything. I have not written anything. Lordship. Outside it. Till your lordship's book is ready.
Try ulta written. In other cases also I have found like that.
Yes.
Lordship. Out of total 8 witnesses, Lordship, PW 1 to 4 have claimed to be the eyewitnesses to the occurrence, Lordship. But their statements do not corroborate each other, Lordship. And there are material contradiction, Lordship.
Who is the jar?
Lordship will find the FIR, Lordship, page number 4 of the paper book, Lordship. May I read, Lordship? Informant is the father of the victim, Lordship. Sir, humble submission is that around 9 a.m. today, that is on 30/4/2018, while my youngest son, Sevaklal Chauhan, 6 years old, was sleeping in a swing made of cloth in the veranda of our house, my younger brother, Sri Vedilal Chauhan, took him from there and killed him by hacking on his head with a hoe in a vegetable garden near his house. Thereafter, he fled away. I therefore pray to you to take necessary action, legal action against the said accused after investigating into the matter and oblige. Thereafter, he was taken into custody the same day, 30/4/2018, Lordship. Thereafter, Lordship, during trial, Lordship, charges under section 302 and 201 were framed, Lordship.
Yes.
Then Lordship may kindly come to the evidence of PW1, Lordship, page number 8. Lordship has found it.
Yes.
He is the father of the deceased son. I am the informant of this case. Victim deceased Sevaklal was my son. Accused Bedilal Chauhan is my brother. The occurrence took place on 30/4/18 at about 9 a.m. On the same day of occurrence, I was at working place nearby my village. After some time, the accused went to meet me at my working place and asked me to put my signature in the sale deed. Then I told him that I will put my signature after having brief discussion about the share of land with other brothers. The accused threatened me if I do not put my signature within 9 a.m., then he will commit some offense. On that day, he came back home at about 9 a.m. and he caught hold of my son who was sleeping in a jhulna, which was hanging in the veranda. At that time, my another son informed me that the accused took away my son Sevaklal. When the accused was taking away the victim, my wife and my sister tried to restrain him, but he assaulted my sister with a spade and she fell down on the ground. After getting information, I rushed to my house. At the time, he was holding my son and asked me whether I would put my signature or not. While I refused to do so without having discussion, the accused assaulted my son with a spade on his head in front of me. I, along with Sugrim is the PW2, took my son to Hujai PS. Thereafter, I took my son to hospital, but he died. On the same day, I lodged the FIR against the accused. Police conducted inquest over the dead body of my son in presence of me. I also put my signature in the inquest. Exhibit 1 is the FIR and Exhibit 1:1 is my signature. Exhibit 2 is the inquest report and Exhibit 2:1 is my signature. So he was taken to police station instead of Lordship hospital. In normal circumstances, the deceased would have been taken to hospital. Then cross Lordship, we are 2 brothers and 2 sisters. One of my sister is married. We, the brothers, stay separately by constructing separate house. There is a dispute in respect of landed properties. My mother used to stay with the accused, but presently she is with me. It is not a fact that I kept the sale deed with me forcefully and I went to the house of the accused person to do quarrel with him. It is not a fact that accused did not go to my working place and did not ask me to put my signature on the sale deed. On the relevant day of occurrence, my sister Subhadra, my wife Durgavati, and my mother Jyoti Devi were present at home. It is not a fact that there was fighting between me and accused person in which the victim sustained grievous injuries and led him to death. Police interrogated me on the next day of occurrence. It is not a fact that I did not state before police that my sister sustained injuries while resisting the accused person to take my son away. It is not a fact that the accused person did not commit murder to my son. Then Lordship, PW2 Lordship, page 10. Sugrim Chauhan Lordship. I know the informant as well as the victim deceased Sevaklal. I also know the accused Bedilal Chauhan. The occurrence took place on 30/4/18 at about 9 a.m. On the day of occurrence in the morning, accused came to my house and he told me that he was going to sell his land and he requested me to present at the time of selling the land and also requested to favor me. I suggest him to sell the land by obtaining signature of his mother, as she was the actual owner. At that time, the accused Bedilal Chauhan was in drinking condition and he is in his control. Thereafter, he left from my house. At about 9 a.m., I was taking my meal and I heard hue and cry in the house of Bharatlal Chauhan regarding taking of his son forcefully by the accused person. After finishing my meal, I came out after hearing the sound of screaming, and I saw the accused person was with a spade and the victim was lying on the ground in front of him. At that time, I saw my elder brother Bharatlal Chauhan. He claimed that the informant was his elder brother, but here the father's name is shown as different. PW2, Bir Bahadur Chauhan,
1 minute.
late K. Chauhan. But he claimed that the informant was his elder brother. I saw my elder brother, Bharatlal Chauhan, was coming and telling him to leave the victim. Then the accused assaulted with the spade to the victim in front of me on his head 2 times. Thereafter, the accused person coming towards to Bharatlal Chauhan, the informant, to attack him. Later on, the accused person fled away from the PO with the spade. Subsequently, the victim was taken to the police station, PS, by the informant and then to hospital where the victim died. I saw injury marks on the head of the victim. Police conducted inquest over the dead body in presence of me, where I put my signature as witness. Exhibit 2 is the inquest report and Exhibit 2 is my signature. So he claimed to have seen the occurrence in front of his own eyes. It is a fact that there was a dispute between the informant and accused person in respect of landed property. I cannot say whether there is this dispute between them in respect of a plot of land. It is a fact that I did not state before police that in the morning, the accused person came to my house and requested me to be a witness in respect of selling a plot of land. It is a fact that I did not state before police that I saw the occurrence by myself, as the police did not ask me specifically. It is not a fact that I am deposing falsely before this court. It is not a fact that accused did not kill the victim in front of me. On the relevant day of occurrence, Subhadra Kumari, that is PW3, the mother of the accused Durgavati Devi, were also present there. So, Lordship, the PW2 claimed that he is the eyewitness, Lordship. But, Lordship, there are contradictions between PW1 and 2. PW1 never mentioned that PW2 was there. Then, Lordship, PW3, Subhadra Kumari, sister of the informant, page 12, Lordship. I know the informant as well as the victim. This is Sevak Lal. I also know the accused Bedilal Chauhan. Informant Bharatlal Chauhan is my elder brother. Accused Bedilal Chauhan is also my elder brother. The occurrence took place about 4 or 5 months ago at about 9 a.m. On the day of occurrence, my accused brother Bedilal Chauhan came to our house and asked me about my another brother Bharatlal Chauhan. Then I replied that he was at his working place. Then the accused took my nephew Sevak Lal and left the house. Then we informed my brother Bharatlal to come home. Then the accused killed the victim. Page 12.
Page,
12. PW3.
yes, proceed.
May I read from the beginning?
Yes.
I know the informant as well as the victim. This is the Sevak Lal. I also know the accused Bedilal Chauhan. Informant Bharatlal Chauhan is my elder brother. Accused Bedilal Chauhan is also my elder brother. The occurrence took place about 4 or 5 months ago at about 9 a.m. On the day of occurrence, my accused brother Bedilal Chauhan came to our house and asked about my another brother Bharatlal Chauhan. Then I replied that he was at his working place. Then the accused took my nephew Sevak Lal and left the house. Then we informed my brother Bharatlal to come home. Then the accused killed the victim Sevak Lal with a spade. When the victim was taken by the accused person at that time, I along with my sister-in-law and my mother objected and tried to resist him, but the accused also assaulted us. Thereafter, the accused kept the victim child on the ground, pressed him with leg on his head, and thereafter assaulted him with spade on his head. And the said occurrence was witnessed by me. The victim child died on the way while he was taken to hospital. I was also taken to hospital for my treatment. Then Lordship cross. At the time of occurrence, the father of the victim, Bharatlal, was not present at the PO. This is important, Lordship. At the time of occurrence, the father of the victim, Bharatlal, was not present at the PO. He came after 10-15 minutes of the occurrence. When the father of the victim came to the PO, at that time, the accused was not present there. At the time of occurrence, Sugrim Chauhan was not present there. Sugrim Chauhan is PW2, Lordship. He was taking food in his house, and after hearing Halla, he came out. When he came, the accused has almost left the PO. At the time of occurrence, the accused was not in drunken condition. The distance between our house and the accused person is about 50 feet away. Police did not interrogate me or take my statement. Police came to the PO on the day of occurrence. I went to PS and then sent to hospital for my treatment. I went to the PS just after the occurrence. Now I stay with informant. It is not a fact that I have not witnessed the occurrence and I am deposing false evidence before this court. It is not a fact that I did not sustain any injury. It is not a fact that whatever I have deposed in my chief today is false. So according to PW3, PW1 and 2 were not present at the time of occurrence, at the PO, Lordship. But while PW1 and 2 said they were present. So there are, Lordship, material contradiction regarding the presence of the PW1 and 2. Then, Lordship, page number 14, PW4. Mother of the informant. Informant Bharatlal Chauhan is my son. Accused Bedilal Chauhan is also my son. The occurrence took place about 6 months ago at about 9 a.m. in the morning. On the day of occurrence, while my son Bharatlal Chauhan was working nearby house, then the accused Bedilal Chauhan went there and met him and asked him to put his signature to sell a plot of land. Thereafter, the accused came to our house and took the victim child with him forcefully after assaulting my daughter, Subhadra Chauhan, who is PW3. The accused brought the victim child to his house and thereafter cut him with a spade. So PW3 is saying that the accused took the deceased victim to his house, whereas PW1, 2, and 3 said that he was, Lordship, attacked in the house of informant. The accused brought the victim child to his house and thereafter cut him with a spade. After the occurrence, the accused took his bicycle and fled away from the PO. I was also requesting him not to kill the victim child, but he did not listen to me. The accused also threatened me with dire consequences if I do not put my signature in the sale deed. Then, Lordship, cross. I cannot say whether the accused took alcohol on the day of occurrence. On the day of occurrence, the accused was also chasing me to assault, but I ran away. Police came to our house and asked the other family members. I was not in sense and police did not ask me. There was no quarrel between the accused and Bharatlal, Lordship. As and when Bharatlal came to the PO, then the accused killed the victim child. When my son Bharat was coming to the PO, then before him the victim was killed. Bharatlal was working about half a kilometer away from the PO at the time of occurrence. I regained my sense on the same day in the evening. Police came to our house repeatedly for several times. I never went to the PS. The accused had the sale documents at the time of occurrence in his hand. So as per PW4, Lordship, accused had also had the sale documents in his hand, Lordship, at the time of occurrence in his hand. Now I am staying with Bharatlal and he takes care of me. I have earlier filed a case against the accused in PS police station, and since then I am living separately. It is not a fact that I am giving false evidence because I love one of my sons, Bharatlal Chauhan. It is not a fact that I did not witness the occurrence and that is why police did not record my statement. It is a fact that whatever I have stated today in my evidence in chief had not stated the same before the IO, as he did not ask. It is not a fact that I did not witness the occurrence and have deposed falsely today. The accused took the victim child from our house while he was sleeping at veranda. Then thereafter, the accused assaulted the victim child in his house near veranda and caused injury on his head. At that time, I was in my house in front of my door and watching the occurrence. At that time, my daughter Subhadra was also with me. She was also watching the occurrence. As per PW4, occurrence took place in the house of deceased, house of the accused, Lordship. And she was witnessing the occurrence from the house of the informant.
Near the veranda.
Near the veranda. And also the accused killed the deceased in his veranda. So these are the material contradictions, Lordship. Then PW5, Lordship, there is the doctor who conducted, Lordship, post-mortem report. Page 16. On 34/18, I was working as senior medical and health officer at BPCH, Nagaon. On that day, I did post-mortem examination on the dead body of one Sevak Lal Chauhan, aged about 6 years, male body, and the dead body was identified by UBC, Til Bahadur Chauhan, Sugrim Chauhan, and Bharat Lal Chauhan. During examination, I found deep cut injury on left side of head, size 4/3 cm, and a deep cut injury on the right side of head. In my opinion, the cause of death was due to shock and hemorrhage as a result of injury described. Exhibit 3 is the postmortem report, and Exhibit 3.1 is my signature. Lordship, proceed. I have not mentioned the type of weapon caused that injury. Lacerated injury may occur due to fall on hard substance. Both the injuries were lacerated. The shock and hemorrhage caused to the victim is sufficient to cause him death. Lacerated injury may cause death of a person which depends of the size of the vital organ. If rigor mortis is present on the dead body, which can be presumed that the duration of death is within 24 hours. We give the date time of approximation. The exact time of the PM has not been mentioned in Exhibit 3. It is not a fact that the cause of death, which I have mentioned in the PM reports, is sufficient to cause him death. So he said that it is not a fact that the cause of death, which he has mentioned in the PM, is sufficient to cause the death. So he has contradicted his own version, the doctor. According to him, is not the injury is not sufficient to cause the death. This is important, Lordship. Then, Lordship, PW6 is the Caesar witness, Lordship. Page 17. I know the informant as well as the victim. This is Sevak Lal. I also know the accused Bedilal Chauhan. The occurrence took place about 4 months ago at the house of informant. He was deposing in the month of December. He told that about 4 months ago the occurrence took place. Whereas the occurrence took place in the month of April, Lordship. 8 months prior to his deposing in the court. The occurrence took place about 4 months ago at the house of informant. There is a dispute in respect of land between the informant and accused. On the relevant day of occurrence, I heard about the occurrence that the accused Bedilal Chauhan, after cutting the victim child with a spade, trying to flee away. After getting that information, I, along with police, started searching him. But we came to know that the accused Bedilal Chauhan gone towards Amtola, and thereafter he went to Kurkut Bosti, Salbagan. In the meanwhile, some of our nephews tried to catch him, but again he flew away. Finally, the accused was apprehended from Jamuhandal village, where he was drinking. Subsequently, we recovered the spade from the place near the Gobind Singh's house. This Gobind Singh was never examined, Lordship. Where the accused left the spade. The spade was recovered as per version of leading to discovery. The said spade was speared with blood. This is important, Lordship. The said spade was speared with blood. But subsequently, in the FSL report, no human blood was found as per the IO. The said spade was Tata brand. The said spade was seized in presence of me. Exhibit 4 is the Caesar list, and Exhibit 4.1 is my signature. Then Lordship, cross. On the next day morning at about 6 a.m., police recovered the spade. The said spade is not seen today in the court. Police recorded my statement on the next day of occurrence at PS. And I have put my signature in the Exhibit 4.1 at the PS. It is a fact that I did not state before police that I, along with police, chased the accused and apprehended him. It is also a fact that I did not state before the police that I heard about the incident. It is a fact that I did not state before police that accused tried to flee away after committing the offense. So these facts he did not state before police. The accused was in drunken condition when we apprehended him from Jamuhandal village. I have not heard that prior to the occurrence he was in drunken condition. After the occurrence, I went to the house of informant and came to know about the incident, that the incident occurred at the house of Bharatlal Chauhan. He is the informant. I heard that the accused had killed the victim by hanging in a guava tree. And this was told to me by Bharatlal Chauhan, the father of the victim, Lordship. So he was informed by the informant that the accused had killed him by hanging in a guava tree. But the prosecution case is defined, Lordship. He killed with a spade. I had gone to the PO after 3 to 4 hours at around 10 a.m. I put my signature in a written paper, but what was written there not read over to me. They only told me that I have to give evidence when I put my signature in the Exhibit 4. I have not seen Chotelal Chauhan at police station, and Chotelal Chauhan was present in the place where the weapon was recovered. Chotelal Chauhan was in NRC duty at the time of recovery, and subsequently Suresh Chauhan was also was also signed in the exhibit 4 at PS. In presence of me, I do not know whether the police recorded the statement of the accused Bedilal Chauhan or not, and the police has not taken my signature in the statement of accused before proceeding to recovery of the weapon. I myself have not seen that the accused flee away. I had only heard this from the villagers, but I do not remember their names. So he had not seen the accused fleeing away from the place. It is not a fact that the accused did not flee away by throwing the spade near the house of Gobind Singh Chawla. It is not a fact that I have stated that the weapon was recovered from near the house of Gobind Singh Chawla. I have not witnessed the incident myself, and I have heard about the incident from the father of the victim. It is not a fact that I have stated falsely today before this court. So his evidence is also of vital importance, Lordship, particularly his cross Lordship. And that person nearby whose house the spade was alleged to be recovered was an examined, Lordship, Gobind Singh. Then Lordship, PW 7. PW 7, page 19, Lordship. He is also Caesar witness, Lordship. I know the informant as well as the victim, deceased Sevak Lal. I also know the accused Bedilal Chauhan. The occurrence took place about 2 months ago. He was deposing in the month of December. He told that the occurrence took place about 2 months ago, whereas it was in April 2018, Lordship. On the relevant day of occurrence, it was at NRC office. I was at an NRC office, and I heard about the occurrence from villagers, and thereafter I went back to the NRC office. I heard that the accused Bedilal Chauhan had killed the child. Later on, I came to know that the accused was apprehended and brought to Huzai PS. Thereafter, I do not know anything. Cross Lordship. The house of the accused is situated about 100 meters away from the house of informant Bharatlal Chauhan. I sometimes used to go to the house of the accused and the informant if required. Police did not record my statement. Police did not meet me in connection with this case. Police took my signature in the PS. I cannot say in which paper police obtained my signature. I could not remember from whom I heard about the incident. It is a fact that I have not stated before police that what I have stated today in my evidence in chief. It is not a fact that I have heard about the incident that accused Bedilal Chauhan fled away and he was captured later on. So, Lordship, these two are the Caesar witnesses, Lordship. It cast also serious doubt regarding recovery of the Lordship spade. Because this PW7 has signed on the paper, he did not know anything about the contents, Lordship. This PW8 Lordship is the IO Lordship. Page 20. On 34/18, I was working at attached officer at Huzai PS. On that day at about 10 a.m., one Sri Bharatlal Chauhan came to Huzai PS and informed that his minor son Sevaklal Chauhan was assaulted by his brother Bedilal Chauhan on his head and caused grievous injury. Accordingly, the OC Huzai PS made GD entry by Huzai PS GD entry number 103 dated 34/18 and directed me to take necessary step and send the injured child to Huzai FRU. I took the victim to hospital, but doctor declared him dead. Thereafter, I prepared to conduct the inquest, and the inquest was done by Executive Magistrate Huzai. I recorded the statement of inquest witness, namely Sugrim Chauhan and Bharatlal Chauhan. Thereafter, I sent the dead body to Nagaon BPCH for conduct PM over the dead body. I also medically examined another victim, Miss Subhadra Chauhan, the sister of the informant, Lordship, who was Lordship told that she also sustained some injury. On that day at about 1 p.m., I visited the place of occurrence, and after arriving there, I found that the accused Bedilal Chauhan was detained by local public while he tried to flee away, and hence I took him in my custody. So he was detained by local public, but none of the public has been examined. All are the family members of the Lordship, the deceased informant, Lordship. Lordship, I visited the PO, and after arriving there, I found that the accused Bedilal Chauhan was detained by local public while he tried to flee away, and hence I took him in my custody. I visited the PO and drew a rough sketch map. I also recorded the witness available at PO, namely Rita Devi, Subhadra Chauhan, Jyoti Devi, Umesh Chauhan, and Rajendra Chauhan. After examining the eyewitness, it was found that the accused Bedilal Chauhan assaulted the son of the informant with a spade by taking the child from veranda where the child was sleeping at Julna. Thereafter, I came back to PS along with the accused. On the same day at about 4 p.m., Bharatlal Chauhan, the father of the deceased, lodged an FIR. On the same day at about 4 p.m., Bharatlal Chauhan, the father of the deceased, lodged an FIR at Hujai PS, which was registered as Hujai PS case number 296/18, and OC Hujai PS endorsed me to investigate the same. After receiving the FIR, I recorded the statement of Bharatlal Chauhan. I also recorded the statement of accused Bedilal Chauhan. In his statement, accused confessed that he had killed the child with spade. He also confessed that there was a dispute regarding sharing of their landed property between the informant and accused. He also confessed that he was ready to show the spade where he kept it. I arrested the accused on 1/5/18 at about 8:40 a.m. Next day, Lordship. I again went to the PO along with accused. I again went to the PO along with accused to recover the spade, which was used in the alleged offense. On his leading, I recovered the spade near from the LP school Hujai. Accordingly, in presence of the witness, I seized the spade. Also recorded the statement of Caesar witness. Thereafter, after medical examination of the accused Bedilal Chauhan, I forwarded the accused to judicial custody. I also sent the seized spade for FSL examination. I also collected the medical report of the injury of Subhatra Chauhan, PW3 Lordship, and also collected the PM report of the deceased. I also collected the FSL report from Guwahati, but it was not exhibited, the FSL report. But he collected the same, Lordship. I filed the charge sheet against the accused Bedilal Chauhan under section 302-201 IPC. Exhibit 5 is the charge sheet submitted by me, and Exhibit 5.1 is my signature. Exhibit 6 is the rough sketch map of discovery of the seized spade, and Exhibit 6.1 is my signature. Exhibit 7 is the rough sketch map of the PO, and Exhibit 7 is my signature. Exhibit 4 is the Caesar list of spade. Is the Caesar list of spade, and Exhibit 4.2 is my signature. Exhibit 3 is the signature of accused Bedilal Chauhan in the Caesar list under objection. Exhibit 8 is the extract copy of Hujai PS GD entry numbers 103-3418. Exhibit 1 is the FIR. Exhibit 1.2 is the endorsement note of the OC Hujai PS. And Exhibit 1.3 is the signature of OC Hujai PS, Kiteshwar Bonia, which I can recognize. Exhibit 9 is the CD. Exhibit 9.1 is the confessional statement of accused Bedilal Chauhan. Exhibit 9.2 is my signature under objection. Then cross Lordship. The informant Bharatlal Chauhan had reached Hujai PS on 34/18 at around 10 a.m., but he filed the Ejaha, that is Exhibit 1, at 4 p.m. after Lordship around 6 hours. As per Exhibit 1, the time of occurrence is 9 a.m. In the Exhibit 1, there is a column number 8 to give reason for the delay in lodging the complaint. But in Exhibit 1, no reason for delay has been cited. There is no any mention of any GD entry of Hujai PS regarding the incident in FIR from form of Hujai PS case number 296/18. There is no any mention of any confession made by the accused before me in my charge sheet. That is Exhibit 5. As per Exhibit 6, the spade was not recovered from the house of one Gobind Singh Chauhan. His house is situated at the far off place of the PO. As per Exhibit 6, near the place from where the weapon was recovered, there was house of one Samir Gupta. And I don't record the statement of said Samir Gupta. This Samir Gupta was not Lordship, also not examined Lordship. I recovered the spade from an open place in front of LP school, and it was accessible to public round the clock. As per Exhibit 7, there is a field between the house of the informant. At the time of occurrence, there were crops in the cultivable lands lying between the house of informant and accused. The recovery of alleged weapon, that is spade, and Exhibit 6 were made on 1/5/18. Exhibit 7 was prepared on dated 34/18. I have not recorded the statement of Harijan, whose house is situated near the place of occurrence. There is no mention of the blood-stained cloth seized from the body of the deceased in my Caesar list. So blood-stained cloth was also recovered from the body of the deceased, but not mentioned in the Caesar list. Exhibit 4, I have not seen and produced the seized spade today in the court. I have not specifically mentioned in my Caesar list, Exhibit 4, that there is not any blood stain on the seized spade. While I recorded the alleged confessional statement of the accused, that is Exhibit 9.1, the accused was in police custody and he made it being in police custody. I did not take the signature of any independent witness, despite that there were available independent witnesses present in the PS at a relevant point of time. I have not seen today any judicial confession statement made by the accused in the court. It is not a fact that the accused did not confess before me and no recovery of spade was made. as laid and shown by the accused. It is not a fact that the signature of the witness in the seizure list on Exhibit 4 was taken in the PS and no recovery of spade was made as per Exhibit 4. It is not a fact that the signature of the accused was obtained in PS. It is a fact that PW1, Bharatlal Chauhan, stated before me that his sister sustained injury while resisting the accused person. It is not a fact that I did not take the statement of the witness Subhadra Chauhan. It is a fact that PW6 Ramayan Gwala, who is a VDP secretary, has not stated before me that the recovery of the weapon was not made from the house of Gobind Singh Chauhan. As per FSL report, no human blood was found on the seized spade. This is important, Lordship. As per FSL report, no human blood was found on the seized spade. It is not a fact that I did not investigate the case properly and submitted a charge sheet without having sufficient evidence against the accused. It is not a fact that I have deposed falsely and the accused has not committed any offense, Lordship. So these are the prosecution witnesses, Lordship. These are their version, Lordship. PW 1 to 4, who claim to be the eyewitnesses, Lordship, their statements do not corroborate each other, and they are, in my humble submission, material contradiction, Lordship. And PW 6 and 7, who were the Caesar witness, also, Lordship. Caesar is also doubtful, Lordship. And there was no human blood found in the spade. Although PW 6 said that it was spared with blood, Lordship. Thereafter, Lordship, the injury report of the PW3 was also not examined, also not exhibited, Lordship, which casted doubt that whether she was injured at all, because there was no report, Lordship, although she was examined. Then, Lordship, 313 CRPC, all throughout the accused had denied, page 23 onwards. He said that he asked the informant to put his signature for selling my land, but he did not kill the victim. Answer to question number 1, Lordship. Then, Lordship, impugned judgment, page number 27, Lordship.
Yes.
The learned court below, Lordship, frame 2 points for determination, page 29, Lordship.
164 statement was taken.
164 was not taken. Points for determination, point number 1, whether the accused Bedilal Chauhan on 34/18 at about 9 AM committed murder by causing death of victim Sevaklal intentionally as alleged. Number 2, whether accused Bedilal Chauhan on 34/18 at about 9 AM caused death to the victim Sevaklal Chauhan and thereafter concealed the spade with intent to cause disappearance of evidence as alleged, Lordship. Thereafter, Lordship, appreciation of evidence, Lordship.
Yes.
Lordship will find the operative part at page number, Lordship, 11, Lordship. Page, Lordship, para 10, page 35. Para 10, page 35, Lordship.
Yes.
Learned counsel humbly submitted that that every accused is presumed to be innocent unless the guilt is proved. The court must be on guard to see that merely on the application of the presumption, the same may not lead to any injustice or mistaken conviction. The ocular witnesses are relatives of the informant and thus they are interested witnesses. In the seized spade, no human blood was found by the FSL. There was no judicial confession made by the accused person and the leading to discovery of seized spade is doubtful. Despite that, there are glaring contradictions which dislodges the substratum of the prosecution case and thereby accused deserve equitable and benefit of doubt, Lordship. This was a submission made on behalf of the accused before learned trial, Lordship. Para 11, Lordship. In cumulative and careful analysis of the evidence on record in the entirety, it surfaces that the accused Bedilal Chauhan wanted to sell his share of his landed property, and in this regard, he wanted to obtain the signatures of other co-sharers. In order to procure the signature of his brother informant, he perpetrated the offense on 34/18 at about 9 AM in the morning. On the day of occurrence, while the informant Bharatlal Chauhan was working nearby his house, the accused Bedilal Chauhan went there to meet him and asked him to put his signature in the sale deed. When the informant told that he has to discuss the matter with other co-sharer, then the accused infuriated and accused expressed his intention that if he does not put his signature, then he will commit some offense. After returning, he directly went to the house of informant and forcefully took the victim minor child Sevak Lal Chauhan, aged about 6 years, from the veranda where the victim boy was sleeping in a Julna. When the accused was taking away the victim boy, then the sister of the informant Subhatra Chauhan and his mother was tried to restrain him, but the accused assaulted Subhatra Chauhan and caused her injuries. The accused brought the victim child to his house and thereafter cut him with a spade on his head. After the occurrence, the accused took his bicycle and fled away from the PO. This fact is thoroughly corroborated by the ocular witnesses PW 1, 2, 3, and 4. In the evidence, PW1 unambiguously stated in his evidence that after getting the information, he rushed back to his house and saw that the accused was holding his son and asked him whether he would put his signature or not. While he refused to do so without having discussion, then the accused assaulted his son with a spade on his head in front of him. Soon after the occurrence, he along with one Sugrim, PW2 Lordship, took his son to Hujai police station, but he died. In conformity with PW2 stated that on the relevant day at about 9 a.m., he was taking his meal and he heard suddenly hues and cries in the house of Bharatlal Chauhan regarding taking away of his son forcefully by the accused person. After finishing his meal, he came out and saw the accused was with a spade and the victim was lying on the ground in front of him. At the time, he said his elder brother Bharatlal Chauhan was coming and told to leave the victim boy, but he did not listen, and then the accused assaulted with the spade to the victim in front of him on his head 2 times. Corroborating another ocular witness, PW3, revealed in her evidence that when the victim was taken by the accused person, at that time she along with her sister-in-law and her mother objected and tried to resist him, but the accused assaulted them. Thereafter, the accused kept the victim child on the ground by pressing him with leg on his head and then assaulted him with a spade on his head. Having consistency with PW4, mother of the accused, an informant stated in her evidence that the accused took the victim child from their house while he was sleeping at veranda, and thereafter the accused assaulted the victim child in his house near veranda and caused injury on his head. At that time, she was in her house in front of the door and watching the occurrence. The aforementioned testimonies are not at all shaken at all and thus inspire confidence. Their evidences are found wholly reliable and trustworthy in absence of impeachment. To the extent of injuries, the medical testimonies, that is PW5, Dr. Latifur Rahman stated in his evidence that on postmortem examination on the dead body of one Sevak Lal Chauhan, aged about 6 years, male body, he found a deep cut injury on left side of head measuring 4 by 3 cm and a deep cut injury on the right side of head. He opined that the cause of death was due to shock and hemorrhage as a result of injury described. There is no discrepancy as such to discard the medical testimony. In respect of Caesar, the IO revealed that in his evidence that on being laid by the accused person, he recovered the spade which was used commission of offense. The Caesar witness PW 6 and 7 corroborated by exhibiting their signature in Exhibit 4. Thus, it is evident from the corroborated testimonies on the proven facts and circumstances that it's none other but the accused Bedilal Chauhan on 34/18 at about 9 a.m. assaulted with a spade on the head of victim Sevak Lal Chauhan and caused him grievous cut injuries which led him to death. So the Lanet trial court did not at all consider that there are material contradiction between the PW 1 to 4 lots. One saying that the occurrence took place in his house, he saw with his own eyes. 2 saying something else. 3 and 4 said that the accused took the victim to his house and killed in his veranda, and she was watching from the house of the informant. So these aspects were not considered by Lanet trial court. And thereafter, Lordship, para 12 charges under section 302-201 IPC. In the case in hand, one of the charges framed against the accused under section 302 of the IPC 1860, and thus it pertinent to discuss that the penal provisions for commission of murder prescribe the punishment to the extent of death or life and shall also be liable to fine. As per section 300 IPC, murder is defined as except is definition, Lordship. Then there are, Lordship, exception to the section 300, Lordship. Then, Lordship, paragraph 13, Lordship. In the present case, it has been proved beyond doubt that the accused Bedilal Chauhan wanted to sell his share of landed property And in this regard, he wanted to obtain the signature of other co-sharers, Lordship. Lordship, how it was proved beyond doubt that he wanted to sell his share of landed property, that Lordship trial court did not appreciate. In order to procure the signature of his brother informant, he perpetrated the offense on 34/18 at about 9 a.m. in the morning. On the day of occurrence, while the informant Bharatlal Chauhan was working nearby house, then the accused Bedilal Chauhan went to meet him and asked him to put his signature in the sale deed. As and when the informant replied that he needs to discuss the matter with other co-sharer, then he got infuriated and expressed his intention that if he does not put his signature, then he will commit some offense. After returning, he directly went to the house of the informant and forcefully took the victim minor child, Sevaklal Chauhan, aged about 6 years, from the veranda of the house of the informant, where the victim child was sleeping in a julna. While the accused was taking away the victim child, then the sister of the informant, Subhadra Chauhan, tried to restrain him, but the accused assaulted her and caused injuries. That injury part was never proved, Lordship, to Subhadra Chauhan. The accused brought the victim child forcefully to nearby his house and then assaulted, cut him with a spade, and as a result, the victim minor child, Sevaklal Chauhan, died. After the occurrence, the accused took his bicycle and fled away from the PO. Thus, from the above proven facts and circumstances, it is evident that accused Bedilal Chauhan went to the house of informant with an intention to commit an offense, and he did so intentionally and killed the victim minor child, Sevaklal Chauhan, aged about 6 years. The act of accused does not fall within the ambit of the exception under IPC. Thus, it is apparent and distinct from the proven facts and circumstances that the accused Bedilal Chauhan on 34/18 at about 9 a.m. caused death of victim Sevaklal Chauhan intentionally by assaulting with a spade, which amounts to murder, and thereby it attacks the penal provision under section 302 of the IPC against the accused person. In respect of charge under section 201 IPC, it is the offense of causing disappearance of evidence or giving false information to screen offender. Section 201 reads as under, Lordship. 201 is given, Lordship. Thus, in order, Lordship, page 39, from top, line number 4, Lordship. Thus, in order to bring home the said offense, it is incumbent on prosecution to prove the following ingredients. An offense has been committed. Number 2, the accused knew or had reason to believe that such offense has been committed. Number 3, the accused knew or the accused caused disappearance of the evidence thereof. Number 4, the accused gave false information in respect thereof. Number 5, the accused knew or had reason to believe the same to be false. Number 6, the accused did so with intention to screen the offender from legal punishment. Number 7, for aggravating circumstances, the offense in question was punishable with death or imprisonment for life, or with imprisonment extending to 10 years. In the present case, it has been proved beyond doubt by the prosecution that the accused, after commission of offense, took his bicycle along with the spade and kept it in a concealed manner. The said spade, which was used by the accused in commission of murder of victim child, Sevaklal Chauhan, could recover only after being laid by the accused. Thus, it's evident that the accused was causing disappearance of the evidence of the offense committed by him, and thereby it attracts the penal provision of under section 201 of the IPC against the accused Bedilal Chauhan, Lordship. So how it was proved beyond the doubt, Lordship, that that aspect has not been, Lordship, elaborated, Lordship. And thereafter, Lordship, conviction under section 302, 201 has made it out, Lordship. Now, Lordship may come to the charge sheet, Lordship, page number 56. Lordship. 57, there is the name and address of the witnesses and what point each is called to prove, Lordship. There are 12 number of witnesses, but only 8 were examined in the present case, Lordship. 4 of them were not called to the court, Lordship. PW number 4, Lordship, wife of the informant, not called. PW 6, PW 7, and PW 9. These 4 witnesses were not examined, Lordship, during trial. Who could have thrown some light, Lordship. PW 7 may be an independent witness, Lordship. Thereafter, Lordship may kindly come to page number 64, Lordship, rough sketch map of the place of occurrence.
Oh,
64, Lordship.
yes.
Here it is shown that the place A Lordship indicates the place of occurrence and the vegetable garden, Lordship. A. Place of occurrence is shown to be the vegetable garden, Lordship. B indicates the house of accused Bedilal Chauhan. And C indicates the house of complainant Bharat Chauhan. So in between there is a vegetable garden, Lordship. But Lordship, D indicates the house of Sugriv Chauhan, PW2, Lordship. So there is a Lordship distance between A and house of the accused and house of the informant, Lordship. And as per the prosecution case, the place of occurrence is the vegetable garden. But whereas PW1, 2 said that they have seen the occurrence in the house of informant. And PW3, 4, particularly PW4, Lordship, mother of the informant, she said the occurrence took place in the house of the accused, in the veranda. And she was watching the occurrence from the house of the informant, from the veranda. No one told that the place of occurrence is the Lordship vegetable garden, Lordship. No PW, Lordship. And Lordship, the whole occurrence took place in the morning hours, Lordship, in the broad daylight, Lordship. And Lordship, as per the Lordship, IO Lordship, also people took hold of the accused, but none of the independent witnesses have been examined. All are interested witnesses, Lordship, PW 1 to 4. And Lordship, non-exhibiting of the FSL report also cast serious doubt, Lordship. And IO said that there was no human blood found. Whereas according to PW, Lordship, 6 Caesar witness, Lordship, 5 Lordship, Caesar witness, their spade was spared with blood, Lordship. So in this case, Lordship, the presence of the witnesses, Lordship, is Lordship doubtful, Lordship, as well as the place of occurrence, Lordship. Nobody has said that the occurrence took place in the vegetable garden, either in the house of informant or in the house of accused, Lordship. But there is a distance between the house of accused and the informant, as seen from the rough sketch map, Lordship. Lordship, I want to place some judgment, Lordship, of Honorable Supreme Court, Lordship.
Wait. Hmm? You can tell him to talk. Use the AC. Quite cold. Yes.
Lordship, in the 2003 1 SCC 398, Lordship.
2000.
2003 1 SCC, page 398, Lordship. Raghunath versus the state of Haryana, another, Lordship. At para 33, Lordship will find towards the end, Lordship.
So
In the facts and circumstances of the recited above, we are clearly of the view that the prosecution has not come up with the true story. It has suppressed the facts. If that be the case, the whole prosecution story would stand on quicksand. The prosecution has failed to establish this case beyond reasonable doubt. It is now a well-settled principle of law that if two views are possible, the one in favor of the accused and the other adversely against it, the view favoring the accused must be accepted, Lordship. In the present case, there are two views possible, Lordship. One against the accused, one may be in favor of the accused, Lordship. In this case, Lordship, the view going in favor of the accused must be accepted, Lordship. And Lordship, another Lordship, 2004-11 SCC. Page 259.
Yes.
Ram Sevak and others versus State of MP, Lordship. Para 14, Lordship. Para 14.
Yes.
The learned counsel for the State of MP, however, contended that what was stated in the said part of the evidence of PW1 was referable to the inquest report and not the FIR. We have examined the original, which is in Hindi, and the translation is admittedly correct. A reading of this part of the evidence shows that this witness was speaking about two reports. The first report, which is he refers to, must be in regard to the inquest, in regard to which he says that he does not remember if the police took his signatures after the spot inspection. The later part of the evidence certainly refers to his complaint, which he in specific terms states was written on the spot only. Even assuming that there is some doubt as to the interpretation of this part of his evidence, since the same is not clarified by the prosecution by way of re-examination, that the benefit of doubt should go to the defense, in which has in specific terms taken a stand that the FIR came into being only after the dead body was recovered. We also noticed that there is a considerable doubt in regard to the place of incident also. From the medical evidence, we noticed that the deceased suffered 3 major incised wounds, leading to the severance of the blood vessels and amputation of his hand near the wrist, and the body in question was lying at the spot till the police came, which was nearly 4 to 5 hours later. But still, the investigating agency was unable to find any blood on the spot. Of course, the prosecution has given an explanation that after the incident in question, it had rained, but even then it is difficult to believe that even traces of blood could not have been found on the soil in spite of the rain. The absence of any such material also supports the prosecution case that the incident in question might not have happened at the place of incident. In the background of this deficiency in the prosecution case, we think the trial court was justified in coming to the conclusion that the prosecution has not established its case. Hence, the trial court was justified in acquitting all the accused persons. Consequently, we are of the opinion that the High Court was not justified in taking a contrary view. In the present case, Lordship, nobody has said that blood was, Lordship, there in the place of occurrence. Although, as per their version, 2 blows were there, Lordship. 2 head blows, Lordship. So, recovery of human blood from the spade was a different aspect, Lordship. But from the place of occurrence, some blood would have been dropped there, Lordship. But nobody has said, and no blood was also, Lordship, seized from the place of occurrence, Lordship. Lordship, another judgment, Lordship, I will not take much time, Lordship. Absence of blood in the place of occurrence, Lordship, is a serious, Lordship, aspect in this matter, Lordship. No PW has said, no, neither the IO has said, Lordship, that some blood was there in the PO, Lordship. Lordship, in 2003, 3 SCC, 153, Lordship. State of Punjab, Lordship, versus Sucha Singh and others. Paragraph 10 and 11, Lordship. Paragraph 11, Lordship. Mr. Walia, learned counsel, lastly contended that there is a strong motive connecting the accused with the crime, for the reason that Kuldeep Singh, nephew of accused Sucha Singh, was murdered by the complainant party, and the accused had nursed a grudge against the complainant party for revenge. This plea is of no help to the prosecution case. When the basic foundation of the prosecution case crumble down, the motive becomes inconsequential. At the same time, animosity is a double-edged sword. It could be a ground for false implication. It could also be a ground for assault. In the instant case, in view of the facts and circumstances as discussed above, the motive, however strong, merely creates a suspicion. Suspicion cannot take the place of proof of guilt. For reasons aforesaid, we don't find any infirmity in the order of acquittal recorded by the High Court, which warranted our interference, Lordship. In the instant case also, Lordship, the prosecution case foundation has been, Lordship, in my humble submission, crumbled down. And Lordship, thereafter, Lordship, suspicion may occur, but the suspicion cannot take place the place of proof, Lordship. And Lordship, it is well settled principle of law that more serious the offense, the stricter the degree of proof is required, Lordship. So in my humble submission, the prosecution case fails, Lordship, and the impugned judgment of London trial could be interfered with, and the appellant be set at liberty, Lordship. Obliged, Lordship.
May please, Your Lordship. In fact, Lordship, this is a case which is based on ocular evidence. Now, this is of course not the normal procedure. We normally place judgments in the end of our argument. But today I would like to place one judgment first, because there the Supreme Court has culled out few principles how to gauge an ocular evidence in various cases, because ocular evidence sometimes is difficult to reconcile if there are many. Then here is a case where few of the witnesses said he was not there, the other one was not there. So what we have to do is we should reconcile the evidence of all the ocular witnesses. And if we find that it can be reconciled, then we can very well place reliance on that. So Lordship may just like to see one judgment of 22. They have taken the prints. This is the name is little different. Shahaja versus State of Maharashtra. I did not find, I have taken it out from Manupatra. I could not get the citation of SCC. I've taken the prints, Lordship can see. This is Shahaja versus State of Maharashtra. Lordship will go to paragraph 27 straight. 27, Honorable Supreme Court has culled out the principles to be seen while gauging.
1 minute.
Yes, Lordship.
Para?
27. Paragraph 27.
Yes.
Lordship got it? Lordship, Ete got it, perhaps. Yes. Now I'll just read out paragraph 27 slowly. The appreciation of ocular evidence is a hard task. There is no fixed or straitjacket formula for appreciation of the ocular evidence. The judicially evolved principles for appreciation of ocular evidence in a criminal case can be enumerated as under. 1. While appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is formed, it is undoubtedly necessary for the court to scrutinize the evidence more particularly, keeping in view the deficiencies, drawbacks, and infirmities pointed out in the evidence as a whole, and evaluate them to find out whether it is against the general tenor of the evidence given by the witness and whether the earlier evaluation of the evidence is shaken as to render it unworthy of belief. Though there can be two interpretations, if Lordship thinks that it has a ring of truth, then even if there are some infirmities, drawbacks, and it is not overshadowed, Lordship can believe the ocular evidence, saying that, yes, he has spoken the truth. This is what I think my humble submission is. 2, if the court before whom the witness gives evidence had the opportunity to form the opinion about the general tenor of evidence given by the witness, this is not in case here because trial court has the capacity to see. Now, the Supreme Court says the appellate court, which had not this benefit, will have to attach due weight to the appreciation of evidence by the trial court. And unless there are reasons weighty and formidable, it would not be proper to reject the evidence on the ground of minor variations or infirmities in the matter of trivial details. So Lordship will rely on the trial court's appreciation of the evidence and leave aside those minor trivial details. Now, third, when the eyewitness is examined at length, it is quite possible for him to make some discrepancies. But court should bear in mind that it is only when discrepancies in the evidence of a witness are so incompatible that with the credibility of his version that the court is justified in jettisoning his evidence. 4. Minor discrepancies on trivial matters not touching the core of the case. Hyper-technical approach by taking sentences torn out of the context here or there from the evidence, attaching importance to some technical error committed by the investigating officer not going to the root of the matter would not ordinarily permit rejection of the evidence as a whole. 5. Too serious a view to be adopted on mere variations falling in the narration of an incident, either as between the evidence of two witnesses or as between the evidence of this or as between two statements of the same witness, is an unrealistic approach for judicial scrutiny. By and large, a witness cannot be expected to possess a photographic memory and to recall the details of an incident. It is not as if a videotape is replayed on the mental screen. 7. Ordinarily, it so happens that a witness is overtaken by events. The witness could not have anticipated the occurrence, which so often has an element of surprise. The mental faculties, therefore, cannot be expected to be attuned to absorb the details. The powers of observations differ from person to person. What one may notice, another may not. An object or movement might emboss its image on one person's mind, whereas it might go unnoticed on the part of the another. By and large, people cannot accurately recall a conversation and reproduce the very words used by them or heard by them. They can only recall the main purport of the conversation. It is unrealistic to expect a witness to be a human tape recorder. 10. In regard to the exact time of incident or the time duration of an occurrence, usually people make their estimates by guesswork on the spur of the moment at the time of interrogation. And one cannot expect people to make very precise or reliable estimates in such matters. Again, it depends on the time sense of individuals, which varies from person to person. 11. Ordinarily, a witness cannot be expected to recall accurately the sequence of events which takes place in rapid succession or in a short span of time. A witness is liable to get confused or mixed up when interrogated later on. 12 and 13 are the last. 12. A witness, though wholly truthful, is liable to be overawed by the court's atmosphere and the piercing cross-examination by the counsel, and out of nervousness mix up facts, get confused regarding sequence of events, or fill up details from imagination on the spur of the moment. The subconscious mind of the witness sometimes so operates on account of the fear of looking foolish or being disbelieved, though the witness is giving a truthful and honest account of the occurrence witnessed by them. And the last, 13, a former statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction unless the former statement has the potency to discredit the later statement. Even if the later statement is at variance with the former, to some extent, it would not be helpful to contradict that witness. So these are the principles that Honorable Supreme Court has culled out of so many judgments that were passed earlier. Now, taking that into view, taking that into consideration, now we may go into the evidences of the 4 eyewitnesses, the purported eyewitnesses, as they have said. Now, what did PW1 say? He is the informant. He is the father of the deceased. Now, he said, I'll just read out few of his statement. Now, he said that I was working elsewhere, nearby house. First of all, Lordship will see where is the place of occurrence. Lordship will go to the sketch map once. Sketch map, Lordship will find that page 64. Lordship will go to page 64, the sketch map. Now, A, Lordship got it, page 64.
Yes.
A is the place of occurrence and a vegetable garden. And F, Lordship will see the F, these are the Kacha roads. So A is the place of occurrence. B is the house of Bedilal Chauhan, that is the accused. C is the house of Bharat Chauhan, that is complainant. D is Sugriv by the site. Harijan is of course not examined. And F are the Kacha roads. So it seems the place of occurrence was in between the house of the accused and the informant. So it's in the front. So it is visible to all. A, anybody present in the house of C can see it, and anybody present in the house of D can also see it. This is a Kacha road. Lordship will visualize the village areas where there are Kacha roads and there are houses on either side. So C and B's house are there. In between, the occurrence had taken place. But there is no dispute with that fact. Now, PW1, what he said is that he went out to work in a nearby place. In fact, the mother said his working place was half a kilometer away from the place of occurrence. So the complainant, the informant said, I went to my workplace. At 9 a.m., the accused went to take his signature that he wanted to sell his land. And then he said, go and we'll have to take the signature for mother first. And then we will discuss it with other brothers and then we will settle. So he came back, he threatened that if you do not do anything by 9 a.m., I'll commit some offense. So at 9 a.m., accused went and met the complainant and he came back. And at the same time, he came back, he came back at home at 9 a.m. only. Lordship had seen in the judgment, the timings, sometimes the witnesses differ. So we will not go into the exact timing. 9 a.m. he reached that place, 9 a.m. he came back. So it's a small distance. He came back and by guesswork, he said 9 a.m. So 9 a.m. he came back. He caught hold of my son who was sleeping. Lordship will see at page 8, 10 lines from the top. Lordship will skip those 10 lines because he has already read. On that day, 1, 2, 3, 4, 5, 6, 7th line from the top. On that day, he came back home at 9 a.m. He caught hold of my son who was sleeping in veranda. Till this time, he was not there. Accused had not come by then. At that time, my another son informed me that the accused took away my son, Sevak Lal. So taking away part, his other son goes and informs him. When the accused was taking away the victim, my wife, my sister tried to restrain him, but he assaulted my sister with a spade and she fell down on the ground. So this assault was before the incident when he was taking away the child, which was of 6 years old. So after getting the information, so till that time he was not there in the picture. After getting the information, I rushed to my house. At that time, he was holding my son. So he was coming back from half a kilometer nearby his house. Then he saw what? He saw his son being held by the accused. And accused asked me whether I would put my signature or not. When I refused to do so, without having discussion, the accused person assaulted my son with a spade on his head in front of me, on his head. This also is corroborated because the injuries were both on the right and the left side of the head. So I, along with Sugrim, PW2, took my son to police station. No dispute. He was taken first to police station, then to the hospital. So here, complainant, there is nothing to disbelieve that he was not there when the assault on his son took place. He came, he rushed, and he might have seen from a distance. He told him to stop, but then if he, without having any discussion, he had assaulted. Now let us go to the cross, whether that statement is demolished. Now he said, I have 2 brothers, 2 sisters. Their lordship may skip. My mother used to stay with me. Lordship will also skip. Lordship will come to page 9. On the second line, on the relevant day of occurrence, my sister Subhadra my wife Durgapati, and my mother were present at home. So days Durgapati was not examined. Mother and sister were present at home. It is not a fact that there was fighting between me and the accused person in which victim sustained injuries. Police interrogated me. It is not a fact. I did not state before police. My sister sustained injuries while resisting the accused persons. Accused took away. It is not a fact that accused person did not commit. So nothing, his statement in examination in chief was not demolished. So we have nothing to disbelieve the informant. Now going to PW2, Sugrim, whose house Lordship had seen is on the left of complainant's house. Now Sugrim, what he said, initially he said accused went to his place and he was talking about giving signatures on the sale date. He said that go and take your signature from your mother because she is the sole owner till then. Lordship will skip that. At about 9 a.m., 1, 2, 3, 4, 5, 6, 7, 8 line. At about 9 a.m., I was taking my meal and I heard hue and cry in the house of Bharatlal Chauhan regarding, Lordship is rising, no, Lordship's persons came. After finishing, because he, at 9 a.m., while he was taking meal, he heard hue and cry in the house of the informant regarding taking of his son forcefully by the accused person. After finishing my meal, I came out after hearing the sound of screaming. This is taking away, first stage, taking away of the son from the house of the informant to the house of the accused. I came out after hearing the sound of screaming and I saw the accused person was with a spade and the victim was lying on the ground in front of him. At that time, I saw my elder brother Bharatlal Chauhan was coming and telling him to leave the victim. He saw his he's not an elder brother, perhaps cousin brother. I saw my elder brother Bharatlal Chauhan was coming and telling him to leave the victim. Then the accused assaulted with the spade to the victim in front of me on his head 2 times. There are 2 injuries on the head. So they have seen, there nothing, it corroborates. Now he said, I have seen accused person giving his blows on the head 2 times. And during that juncture, at that juncture, the informant was dead. He came, he reached. Thereafter, the accused person coming towards the house of the Bharatlal Chauhan, thereafter the accused person coming towards Bharatlal Chauhan, the informant, to attack him. Later on, accused person fled away from the PO with the spade. Subsequently, the victim was taken to the PS. So he saw, let us go to the cross-examination, which is of course very short. It is a fact there was a dispute between the informant and the accused person in respect of landed property. I cannot say whether there is dispute between them in respect of a plot of land. It is a fact I did not state before police that in the morning, the accused person came to my house and requested me to be a witness in respect of a selling of a plot of land. This, of course, he said it is a fact I did not state. It can be an omission. This is not very relevant to the instant case. In case of ocular evidence, we did not even go to the motive. In certain cases, in absence of motive, in a case where a case is proved by ocular evidence, that's not required. So it can be an omission, not a contradiction that he did not say about the morning part. But he saying is not contradicted. He seeing. It is a fact I did not state before police that I saw the occurrence myself as the police did not ask me specifically. It is not a fact that I am deposing falsely before this court. It is not a fact that accused did not kill the victim in front of me. On the relevant time of occurrence, Subhadra Kumari, the mother, were present there. And Lordship has already gone through the police's statement. These contradictions were not proved. Police did not say. I'll go to that again. So here, he said, since police did not ask me specifically, I did not say. But he, after hearing hue and cry, he came to the place of occurrence and he saw the occurrence. Now, before going to PW3, Lordship will go to the mother statement first, PW4. Because PW3 was assaulted, it is in the evidence, where by the accused when he was trying to take away the child. PW4 seems to have not been assaulted. PW4, Lordship will see the mother statement. My mother said, on the day of occurrence, my son Bharatlal Chauhan was working in the nearby house. Then the accused Bedilal Chauhan went there, met him, asked him to put his signature. Thereafter, accused came to our house and took the victim child with him forcefully after assaulting my daughter Subhadra Chauhan. The accused brought the victim child to his house and thereafter cut him with a spade. After the occurrence, accused fled away. Now, she also had stated that accused had assaulted her daughter. Now, it can be a case where the daughter got assaulted and she might be inside. She did not see who were present at the time of occurrence. I'll go to her statement. But the mother said she was assaulted, even the other witnesses. Now, going to the cross, Lordship will skip 2 lines from the top, 3-4 lines. Lordship will start with the 5th line. As and when Bharatlal came to the PO, she said, as and when Bharatlal came to the PO, then the accused killed the victim child. She also did not say that Bharatlal was not there. She said, as and when Bharatlal came to the PO, accused killed the victim child. When my son Bharat was coming to the PO, then before him the victim child was killed. Then before him, in front of him, this is what she meant. When my son Bharatlal was coming to the PO, then before him, it's not that before he's reaching. She said then before him, in front of him, the victim child was killed. Bharatlal was working about ½ kilometer away from PO at the time of occurrence. Half a kilometer is very near. He said he rushed when his other son went and informed. I regained my senses on the same day in the evening. Police came to our houses repeatedly for several times. I never went to police station. Accused sold the sale documents and so. I need not go into that. Then Lordship will come to page 15, the last but 4 lines. The accused took the victim child from our house while he was sleeping at veranda. Then thereafter the accused person assaulted the victim child in his house near veranda and caused injury on his head. At that time, I was in my house in front of my door and watching the occurrence. So even in her cross, she has reiterated what she had stated in her examination in chief, that I was in front of my house and I have seen the occurrence. So 4 is also an eyewitness, no dispute to that fact. And she said, my son was coming and he saw it. Before him, the child was killed. Now we will go to PW3, the daughter, who had created little difficulty for the prosecution in her cross-examination. Now in her examination in chief, what she said, to the 4th line from the top, on the day of occurrence, my accused brother Bedilal Chauhan came to our house and asked about my another brother Bharatlal. Then I replied he was at his working place. Then the accused took my nephew Sevak Lal and left the house. Then we informed my brother Bharatlal to come home. So immediately after the accused took her nephew, the informant was informed. Then the accused killed the victim Sevak Lal with a spade. When the victim was taken by the accused person, at that time, I along with my sister-in-law and my mother objected and tried to resist, but the accused also assaulted us. Thereafter, the accused kept the victim child on the ground and pressed him with his leg on his head and thereafter assaulted. So what she said, immediately after the nephew was taken away by the accused, they informed the complainant. They informed the informant. And then she was in fact giving her more stress on the first part, taking away the child. She was assaulted. They had resisted. She was assaulted and then the accused killed him. This is what she said. Now in her cross-examination, she says, At the time of occurrence, the father of victim was not present at the PO. Now, what occurrence she is talking of? Because she was stressing more on the taking away of the victim from her house. So at the time of occurrence, the father of victim was not present. He came after 10 to 15 minutes of the occurrence. When the father of the victim came to the PO, at that time, the accused was not present there. At the time of occurrence, Sugrim Chauhan was also not present there. He was taking food. This taking food is okay. Taking food in his house. Even Sugrim was saying that when he was taking food, he heard Halla. And after hearing Halla, he came out. This she said, that Sugrim was taking food. When he heard hue and cry, he came out. Even Sugrim said, when he came, accused has almost, it's not that accused has left the place, occurrence had already taken place. When he came, accused had almost left the PO. This word almost has to be again interpreted. Almost left the PO. At the time of occurrence, the accused was not in a drunken condition. The distance between our house and accused person is only 50 feet away. Police did not interrogate me. Police came to the PO. Lordship can skip that. I went to the PS just after the occurrence. It is not a fact. I have not witnessed the occurrence and I am deposing false evidence. It's not a fact that I did not sustain injury. Though the first point is she was assaulted, she was injured. And as Honorable Supreme Court has said that the witnesses at the, when the incident goes on, when the incident takes place, and it is in the course of that event, when the witnesses sees, then there can be something which they leave out. Here, the incident was taking place. She was assaulted, the baby was taken, and then baby was hit by the spade. She was witnessing the entire incident. She was assaulted. She might be inside the house. She might be somewhere else. So, Honorable Supreme Court has said it can happen that one witness did not speak of the other witness. But we will have to see the totality of circumstances. We'll have to see whether the witnesses are speaking the truth, whether there is a ring of truth in their statements. It's not a case where she is very healthy, she was assaulted, she was injured, and then she said when Sugrim reached, he had almost left. So the incident was going on at that point of time. So her statement, he was not there, in my humble submission, will not demolish the entire evidences of 1 and 2. Mother is again there. Mother said yes. Mother and she were together at the place of occurrence. Mother said, yes, my son came and the incident took place in front of him. So if we read all the evidences together, 1, 2, and 4, it seems, yes, informant has seen, Sugrim has seen, mother has seen, daughter has also seen, but the daughter said these people were not there. But then we can read it because she was assaulted and she used the word almost in case of Sugrim. And she also said Sugrim was having food and immediately after hearing hue and cry, he came out. So those things had to be reconciled with each other so as to reach a particular finding. Lordship will see the statement of, now if I may go to the statement of the medical officer. He said, I found deep cut injury on left side as well as deep cut injury on the right side of the head. Lordship, page number 16, the second paragraph. So 2 injuries, which again corroborates the statement of Sugrim Chauhan, who said there are 2 injuries on the head. He assaulted 2 times. He hit 2 times. So he said, now the last statement that my learned friend was stressing on, it is not a fact, the last statement of the doctor. Initially, Lordship will see the first few statements. The shock and hemorrhage caused to the victim is sufficient to cause him death. Both the injuries were lacerated. Lacerated injuries may cause death of a person which depends on the size of the vital organ. It was on the head. And here the doctor has already given his finding. It was a deep cut injury. If rigor mortis is present on the dead body, which can be presumed that the duration of death is 24 hours, we give the approximate time of death. The exact time of the PM has not been mentioned. Now the last line, it is not a fact, cause of death which I have mentioned in the PO is sufficient to cause him death. Lordship can see this is little, the statement is little incorrect. He said it is not a fact that the cause of death which I have mentioned in the PM is not sufficient. This should have been the right sentence. Is not sufficient to cause him death. This is the original copy. The origin is also like that. It is somewhat an incorrect statement. It is not a fact that the cause of death I have mentioned is sufficient. Is not sufficient. This should be the questions put in the cross-examination and the answers given by the witnesses are somewhat like that. It is not a fact that it is not there. The sentence is little incorrect. Reading, and if we reconcile the statement of the doctor in his chief as well as in his cross, it says that these injuries are sufficient to cause him death. Because in his cross-examination only he said, shock and hemorrhage caused to the victim is sufficient to cause him death. And immediately thereafter he said, it's not a fact, it's not sufficient. So it cannot be, it's insufficient. It is not sufficient to cause him death. It is not a fact. So here there are two injuries, deep cut injuries, and these are the causes of his death, the homicidal death. It's a case of homicidal death. Now PW8 did the police officer. I'm not going into the recovery part because the spade was lying in an open space. And Honorable Supreme Court has time and again said that it should be at least hidden. It should be away from the public view, the object that is recovered. So here the police have said next day, that is on first May, he brings him to the place where the spade is recovered, and they see that the spade was lying on an open field. So leading to discovery, section 27 in my humble submission will not come. Now, why I'm taking to the statements of the IO is to show whether there are any contradictions on the part of the witnesses. Now, Lordship will go to the next page. That is page 22. Page number 22 of the paper book. This is the cross-examination of the police, the IO. It's a big paragraph from the middle part, 10 lines from the bottom, where the contradiction starts, where he deals with the PWs. It is a fact that PW1 Bharatlal Chauhan stated before me, Lordship got it?
Yes.
That his sister sustained injury while resisting the accused person. So sister assaulted is there. It is not a fact. I did not take the statement of witness Subhendra Chauhan. It is a fact that PW6 Gwala, who is a VDP secretary, has not stated before me that the recovery of weapon was not made from the house of Govind Singh. As per FSL report, no human blood was found. It is not a fact I did not investigated the case properly and submitted charge sheet. So none of the witnesses have contradicted. There is no contradiction. No contradiction is proved. So the statement of the witnesses lies as it is. Of course, FSL report I've seen, it is not exhibited. It is in the case diary, and the report is presence of human blood is negated. So the spade, so I'm not stressing on the spade part. We need not, because there are ocular evidences. So FSL Lordship will leave behind. It's not exhibited, not necessary, not relevant for the instant case. Now here, the witnesses of this statement, in my humble submission, all the four, can be reconciled together, and they can be believed that they had seen him assaulting the small baby. And although motive is not required, but motive is writ large in the instant case, that he wanted to sell his property, he wanted to get the signature of the brother, mother was also not willing, and so the entire incident took place. Motive is also writ large. And Lordship has also seen the accused trying to run away. He was somehow apprehended. Land dispute is there. Everyone had stated this. So in my humble submission, these four, there are corroborations. Lordship has seen doctors corroborates the eyewitnesses, and eyewitnesses corroborates each other. So as far as the instant case, all the four witnesses, there is nothing to disbelieve these four witnesses not being the eyewitnesses. They were natural eyewitnesses. No independent eyewitnesses will not matter if we can show that these are natural witnesses and they have a ring of truth, their statements have a ring of truth, and they are believed. Non-examination of other witnesses will not matter. So these are my humble submissions. There is nothing to disbelieve. And Lordship has also seen in the Supreme Court judgment, the findings given by the trial court, who have the audacity to see the witnesses, who can very well read their faces, unless Lordship sees that it is totally unbelievable, should not brush aside the findings of the learned trial court. So learned trial court, Lordship has already read the operative portion, paragraph 11, where the analysis is made. Lordship has already gone through paragraph 11. So there is nothing to disbelieve or discredit this, leave aside the findings of the trial court. These are my humble submissions.
Lordship, small reply, Lordship. So far, the Lordship recovery of spade is concerned. My learned friend has said that it is of no relevance because it was found in open space. In that case, also, Lordship, if it is not the actual weapon of Lordship offense, where is the weapon of offense? Because the boy was hit by a spade. If that is not the spade, then where is the spade? And secondly, Lordship, the IOL said that in cross that there are 6 hours delay in lodging the FIR, Lordship. There is no explanation to that effect, Lordship. What happened within that 6 hours, Lordship? And admittedly, the boy was taken to the police station first, rather than the hospital. In ordinary circumstances, what a prudent man would do, if he was so seriously injured, that he would have been taken to the hospital first to save his life, Lordship, instead of to the police station to show that he has been assaulted, Lordship. That part has not been disputed by anyone, Lordship. Lordship, regarding the motive, Lordship, the informant has also got the motive, Lordship, because there was a dispute regarding property, Lordship. That animosity is, as I have already submitted the judgment, Lordship, is a double-edged sword, Lordship. So in my humble submission, Lordship, only suspicion can come, Lordship, and suspicion cannot take place the proof, Lordship. And Lordship also, injury part of the Lordship, PW3, Lordship. Injuries, she was medically examined and her report was collected by the IO, but it was not exhibited. So what kind of injuries she sustained? Whether she sustained such serious injury that she might have forgotten everything, Lordship. And what she meant by place of occurrence, Lordship, page number 10, Lordship, my learned friend has put emphasis, Lordship, page number 12, Lordship. At the time of occurrence, the father of the victim, Bharatulal, was not present. Occurrence means occurrence of taking away or occurrence of assaulting. That Lordship has to consider, Lordship. And nobody has said that the boy was assaulted in the vegetable garden. Nobody has said that. Because the place of occurrence is shown as the vegetable garden, which was in between the house of the accused and the Lordship informant, as shown in the rough sketch map, Lordship. Nobody has said that the place of occurrence was the vegetable garden, Lordship. Rather, the PW4 stated that he was taken to the house of the accused and he was killed in his house's veranda, Lordship. The vegetable garden, nobody has stated. So at least in my humble submission, the appellant deserves the Lordship benefit of doubt, Lordship.
As far as that 6 hours delay, he said, there is a GD entry because they first took him to the police station. Lordship will get it at page 66. There is a GD entry which was entered into at 10:20 a.m. Page number 66. So that was immediately on 34/10/20. Incident took place at night 9:30 and all. So now Bharatlal Chauhan, so and so, taking along his younger son Sevalal Chauhan with injury on letter's head. This is what is written in the GD entry, has appeared in the PS. Whereupon Badan Chandra Bora is directed to take the injured immediately to Hojai for treatment. It can be mentioned here that Bharatlal has informed that injured Sevaklal was assaulted by his paternal uncle Devilal Chauhan, and accordingly an entry is made in the GD. An effort is made to take necessary steps. So the GD entry is there, the delay in lodging FIR will not come. In spade part, even non-recovery of the weapon of assault is not fatal if there are ocular evidence, which is clear. And the sister was sent for medical examination, but a report and all, I don't find it in the case diary. She was
Also,
otherwise.
Lordship, no recovery of, no seizing of any blood from the place of occurrence. He was hit twice on the head, Lordship. No one mentioned the blood oozed out from his head at the place of occurrence.
Okay.
Obliged, Lordship.
Can you give us your written submissions? When can you do it?
Tomorrow, day after? No,
Day after tomorrow?
Day after tomorrow.
not sure.
Mr.
Anderson, Lord.
And also, let it down, basically. We also had MS. Then it additional PP. Awesome. Then we'll keep it parted, list it day after tomorrow, and then we'll conclude it.
Not.
13 part, list for further hearing. On 18th.
As part had, Lordship.
Parted in the sense just to get.
Submission of that, Lord.
No,
Obliged.
no further.
Obliged.
Seven.
Okay.
Make please, Your Lordship. My lord, kindly have paper book. If your paper book, page 8. Page 8, my lord, FIRs. Page 8, my lord. My lord, to the OC so and so, issuance subject as a on date 29th August 1996. Sir, humble submission is that at about 1 AM yesterday, that is on 29/8/96, around 45 persons of Munda community from Jamapuri village armed with bows, arrows and guns had surrounded the residence of our people of origin community mentioned below and launched arrows and set ablaze the houses. As a result of launching of arrows, Krishna Harijan, Keshav Harijan and Srimati Harijan sustained grievous injuries as arrows hit their stomach, and our homestead and properties were burnt to ashes. Among the miscreants who caused this incident, I could identify Sri Navamunda, Sri Kanumunda, Sri Deepak Munda, Sri Dubal Munda, Sri Suryan Munda, Sri Rajan Munda, Sri Jatya Munda, Sri Mohan Munda, Sri Arjun Munda, Sri Jai Singh Munda, Sri Burma Munda, Sri Tangu Munda, Sri Libya Munda, Sri Lauka Munda, Sri Trisha Munda, Sri Lenga Munda, Sri Vinod Munda, Sri Mantu Munda, and Sri Diman Munda. You are therefore free to take necessary steps for investing into the better end of lives. This is the FIR, my lord. Then your lordship have come to place 12, my lord. Come to please kindly have a look at page 12. In the court of so with the name of the office magistrate Sri N.C. Sahu, IS Deputy Commissioner, Karbi Angan Depot. Name of accused, do hereby charge you. 1, 2, 3, 4, up to 18. 18% have been charge sheeted. 18%. FIR for 45% were assembled basic. Charge sheeted 18%. As follows, my lord. That you are at about 28/9/18 AM at Jamaguri under Hauragat PS, where a member of an unlawful assembly and in prosecutions of common object of such assembly committed the offense rioting and thereby committed offense under section 147 IPC. Secondly, on the same time and place, where a member of an unlawful assembly and did in prosecutions of a common object and such assembly in order to commit offense of rioting with deadly weapons with an intention to cause grievous injuries to the complainant and other of the same village and thereby committed offense under section 148 CRPC. Thirdly, on the same day, time and place where a member of unlawful assembly and prosecutions or common object intend totally to cause injury to one Srimati Saripati Harijan and Krishna Harijan and mischief fire to the village and thereby committed offense under section 149 IPC. Fourthly, on the same day, time and place, voluntary cause hurt to one's Sripati Harijan of village Jamuguri, however, police station with a sharp cutting weapon, thereby committed offense under section 324 IPC. Fifthly, on the same day, time and place, voluntarily caused grievous injury to Kishore Harijan of Jamuguri Gaon PS, Hauragat with a sharp and pointed weapon and thereby committed offense under section 326 IPC. Sixthly, on the same day and time and place, did commit murder by intentionally causing the death of Kishore Harijan, son of late Kariman Harijan, village Jamuguri PS, Hauragat, the bow and arrow, and thereby committed offense under section 302 IPC. Seventhly, on the same time and place, the member of a lawful assembly committed mischief by fire into the 11 numbers of dwelling houses, including machines, shops belonging to the villagers, and thereby committed offense under section 436 IPC. My lord, next page, commitment order. All accused here at present, copy is furnished to the as the offense under section 302, 356, 430 IPC are exclusively triable by the Court of Session. The case record is committed to the Session Court for trial in 1 PP. All the accused persons are to appear before Court of Session on 8/11/2001. PI to produce accused Murki Munda to the Court of Session. Thereafter, the case has been committed and session trial has been started before the Court of Session in Karbi Angan at brief. My lord, therefore, kindly have a look at deposition of PWD1. My lord, I am going it very short because in the last case, earlier case, they took your lordship a lot of time. I will make it cut short, my lord. The deposition of PWD 1 to 11, my lord, page 14 to 32. Page 14 to 32. Page 14 to 32. Page 14 to 32, my lord. Deposition number 1, Sri Ganesh Kumar. Ganesh, has your lordship got?
Yes.
Ganesh Kumar. I know the accused persons present in the dock. They belong to the village Jamuguri, situated at a distance of half kilometer away from my village. village, Tilai Donga. I am a farmer and also the Sarkari Gaubura of village Tilai Donga and Jamuguri area. I also know the complainant Sri Jaleshwar Ram Harijan. He belongs to my neighboring village. I also know the deceased Keshwar Ram Harijan, the father of the complainant. Keshwar Harijan is no more now. I also know Sripati and Sri Krishna, the wife of the wife and the son of Keshwar Ram, respectively. The occurrence took place on 28, 1996 at about 12 midnight. In the day of occurrence, I was sleeping in my home after having meal at about 12 midnight or 10 a.m. I heard some halla in the village. Then I came out from my house and saw the villagers were running around. I, along with the villagers, wanted to go to the village Jamuguri as something was happened there. But in the meantime, some persons came from the village Jamuguri side and they stopped us saying that we might be harmed if we go there. In the meantime, the police also reached the spot and the OC, Hauragat PS, took me along with him to the place of occurrence. At the place of occurrence, I saw that the house of Keshwar Ram Harijan and Surendra Harijan had been burned down in fire. Keshwar Ram Harijan received severe injury on his stomach caused by an arrow, and both Sripati and Sri Krishna has also had received injuries. The OC Hauragat PS inquired about the case and the place of occurrence in my presence. During inquiry, the family member of Keshwar Ram told before police and some persons of village Jamuguri came their house fully equipped with bow and arrows and committed the incident. Police seized some arrows, one piece of half-burnt bamboo, some arrows, etc. from the place of occurrence. Exhibit 2 is the seizure list, and Exhibit 2(1) is my signature. On the same night, the OC Auragat PS and his staff and conducted search operations in the Jamuguri village and arrested the accused persons from their house, who were present in the dock today. In the morning, the injured persons were sent to Auragat Hospital for medical treatment, and the police took the accused persons along with them. I did not go to the hospital. Later, Keshwar Ram Harijan accused to his injuries at Hauragat Hospital. Before the occurrence, a Bisar was held in the village Jamuguri in connection with the kidnapping of a girl, Jorua Munda, who was kidnapped by Chandrakanto Munda. At the time of occurrence, Chandrakanto was living in the house of Surendra Singh to earn his livelihoods. During the Vichar, a clash also had taken place between Surendra Singh and the villagers of Jamuguri village. I think it might be the reason for the occurrence, because the incident took place 2 days after the clash. I informed the police about the Vichar and the clash taken place in Jamuguri village. And cross below, just below, I was not present at the time of occurrence, at the place of occurrence. I do not know who committed the occurrence. The Harijan party had assaulted some of the villagers of Jamuguri village on the day of Vichar. I think it might be the reason of occurrence. He said the earlier one was Vichar was held for kidnapping a girl, and on that day before 2 days there is a dispute between two parties, and it may be the cause of this incident also. And he was not present at that place at the time of occurrence, my lord. Then, my lord, I must mention deposition number witness 2. My lord, shall I read all deposition, my lord? If I leave it to your lordship to see on passing judgment, then I can say also, but some important deposition I may mention, my lord. Then, my lord, go to my lord, very important deposition, my lord, deposition number 4. All depositions almost same. My lord, all depositions are almost same thing. Same thing repeatedly, all deposition, same thing repeatedly, once again, same matter. I mean, one important deposition, my lord, deposition number 4. Can you page,
Without the relevant ones.
my lord, I'm just page number 18. Page number 18, my lord. Because I'm
How many PWs are here?
there's as much as 11 PW. 11 PW. If I read it all, it will take 1 hour. So just to save time, come have a look, page 18, my lord. 18.
Yes.
18. That is Sri Bindeswar Harijan. The deposition witness number 4, my lord. I know the accused persons present in the dock. They belong to the village Jamuguri, Mundabasti. I lived in the village Jamuguri at the time of the occurrence. I was born and brought up in that village. I also I know complainant of the case, Sri Jaleshwar Harijan. He is my elder brother. I know Sri Krishna Harijan is my Krishna Harijan is to also my elder brother. I also know Jaleshwar Harijan, who is also my brother. I also know Sripati Devi, she is my mother. I know Keshwar Harijan, he is my father. My father is no more now. The accused persons had killed my father in this incident. I also know both Surender and Umesh Chandra Ram. Both is my brothers-in-law, and they also lived in our house campus in separate room at the time of incident. I had a grocery shop and a rice mill in our house campus. My father used to sleep in the grocery shop at night. The incident took place in the year 1996, but I do not remember the next exact date on that day. My father was sleeping in the grocery shop. I was sleeping in my room along with my children and wife. On that day at midnight, at around 12:30 a.m., I heard shouts and cries my father from outside. I woke up and came out from my room to the courtyard and saw that a group of 40 to 45 persons armed with bows and arrows had gathered over there, and they set our grocery shop on the fire. All the accused persons were there in the crowd. My father, Keshwar, who came out from the grocery shop, was shot by accused Kanumunda with his bow and arrow in my presence. As a result of my father, Keshwar received arrow injury in his stomach and fell down on the ground. My brother Jaleshwar somehow escaped the scene and went to Hauragat PS and reported the matter to the police. Accused Jatia was my brother. Krishna with his bow and arrow and injured in my presence. Accused Jatia is not present in the court today. The accused Suryanmunda shot my mother Sripati with his bow and arrow and injured her in my presence. My mother Sripati and brother Krishna and received arrow injuries in their stomach. I and other family members saved themselves by hiding behind trees. The accused person and the crowd come down the houses too, burn down the houses too. I could recognize the accused person in the full moonlight and in the light of burning houses. Around 1 hour later, the police visited the PO. Then the crowd of the accused persons fled away from the PO. The police sent my father Keshwar, mother Sripati, and brother Krishna on Haragar Civil Hospital in police vehicle. Later, they were referred to the Deepu Civil Hospital in the same day in the morning. I came to know that my father Keshwar had succumbed to his injuries at hospital. My mother Jaleshwar and local in Gaura Chandrika brought my father's dead body, and the brother Jaleshwar had lost the FIR to this effect. The police examined me and accordingly recorded my statement. My mother Sripati and brother Krishna were admitted to Deepu Hospital for 1 month. Regarding the reason for the incident, the accused Jatia Munda had taken rupees 500,000 of loan from my brother Jaleshwar around 3 months before of this incident. When accused Jatia was asked to return the money, he refused a vichar. I refused. A Vichar meeting also was held in these connections of village, but accused Jatia refused to return money. Baleshwar then reported the matter to the police and sought their help to recover the money. Next day, the accused persons came in the night and carried out the incident. In Cross Milo State, I was present at the place of occurrence on the day of occurrence. I had seen accused Kanumunda with his son father. He had shot my father from a distance of 10 knots. The accused Kanumunda is present in the dock today, and I could recognize him. It is not a fact that the accused person had not committed the occurrence. So, my lord, here he says, my lord, Baleshwar Peterwood 4, he mentioned three of the accused, my lord. The accused Kanumunda. Kanumunda is the affiliate number 8 here. But my lord, he mentioned 3 persons only. And he mentioned one accused Jatia Munda. But Jatia Munda was not present in the cause. He is not in the appellant list. He is not an appellant here before the court. And he mentioned another person, my lord, Suryan Munda. Suryan Munda is not an appellant here because they absconded. They did not appear before the court and no trial has been made against them. So only trial has been made against Kanumunda. Here he mentioned another 2 persons, Jatia and Suryan Munda, is not an accused here because they did not face the trial, they absconded. Now, my lord, in earlier witness first, they are told that there is a kidnapping of the girl and the reasons of the kidnapping of 2 village people. There is an ethnic fight between some Munda and Horijan groups. And for that, a Vichar has been held. And after 2 days of this Vichar, the incident took place. First witness told, here in this witness number 4 is telling that 5,000 rupees they have taken credit from my brother, and we demanded for that money, and money has been refunded. So the occurrence took place. So he's telling about money, and first one telling about the kidnapping girl. These are the different witnesses, my lord. My lord. May I, Lordship, your Lordship, please turn to page 15, deposition of witness number 2. Back, my lord, back. Page number 15. I know the accused persons present in the dock. The accused persons belong to the village Jamuguri at a distance of half kilometer away from my village, Helaidonga. I also know the complainant Ram Horijan of the village Jamuguri. I also the accused Keshwar Ram Horijan, and the complainant he is no more. I also know the Krishna Horijan, the brother of the complainant, Sripati Horijan, the mother of the complainant and the wife of the accused, Keshwar Ram Horijan. Occurrence took place on 28/9/96 at around 12 midnight. On the day of occurrence, I was sleeping after having meal. At about 12 midnight or 11 a.m., I heard some halla from the village Jamuguri. I came out to see what had happened. Then I saw the fire in the village Jamuguri. Other villagers also came out to see what happened. Then I saw the fire in the village Jamuguri. Other villagers also out from their houses on hearing halla. I, along with the villagers, wanted to go to the village. But in the meantime, some person stopped us from going there, saying that it might result in some incidents if we go there. Then I then I went to Heragat PS on my vehicle and reported the OC. Heragat about the matter. Police came to the place on their jeep vehicle, and I went to the place of occurrence on my bicycle. The PO that Keshwar Ram Horijan and received severe injury caused by an arrow on his stomach. And Krishna, the wife and the son of Keshwar Ram, respectively, had also received injuries. I put the villagers that some persons of village injured came fully equipped with bows and arrows attacked the house of Keshwar Ram Horizon. They also set fire in the house of the victim. I, Keshwar Ram, and other injured persons at the place of occurrence. Then the injured persons were sent to medical treatment and returned home. Next day at about 1 to 12 noon, I went to I went to have the injured persons. After a few moments of my arrival at hospital, Keshwar Ram Horizon injuries at Horizon Hospital, the police seized an arrows on being produced by the hospital. Exhibit 1 is the seizure list, and Exhibit 1 is my signature. Material Exhibit 1, which I could recognize in the next court today. Police also seized 5 numbers of arrows, 3 numbers of bow, burnt bamboos from the place of occurrence. Police examined me and recorded my statement accordingly. In cross, he said, my lord, the occurrence took place on 28 to 97 at 12 noon or 11 a.m. I visited the place some morning at about 4 a.m. I was not present at the place of the occurrence. I do not know who has done the occurrence. I have seen only 1 arrows today in the court. I do not know the exact size of the, not seen the other seizure articles in the court today. So he is denying, my lord. He is telling that next day I visited and court. He said that I did not know who has done the deed and who by which and who sent the arrow, who caused the injuries, and who has done it. I do not know. I have not seen anybody. Now, my lord, in this way, all the PWD's prosecution witness gone. Nobody seen exactly who has done the occurrence because it was at about 1 a.m. morning, my lord. So it was a darkness night. So exactly nobody knows who has done the occurrence. My lord, all statements of the PWDs are almost same. Now, very interesting one matter, my lord. If your lordship goes to the examination of accused under section 144 CRPC, my lord, page 41 to 144.
41.
Page 41 to 144. Page 41 to 144. My lord, my name is Sri Rajan Horizon, my lord. He is the appellant here, Rajan Horizon. My lord, Rajan Horizon. Page 41 to 144. My lord, the examination of accused is about 35 years. It is very important, my lord. Taken place, me, A.U. Ahmed, Session Judge, Karbi Anglong, on 18th day of December 2019, in the interpreted by NHR. On, my lord, 18th day 2019, he is telling that my age is 35 years. Occurrence took place in the year 1996. That means, my lord, 23 years, after 23 years, he is telling that my age is 35 years. Then virtually, on the day of occurrence, his age was 6 years or 7 years. He was minor. He was minor. So, my lord, in this aspect, I also argued the matter before the Honorable Justice Koteshwar Singh. My lord, Koteshwar Singh has passed a judgment.
Lordship, once it was heard, then while the argument was going on, your lordship, this honorable could discover the some of the accused person looking into the 313 statement, they were minors, your juvenile, my lord. So lordship, there was this honorable court directed for inquiry. Report came, report dated 11/2021, your lordship, 40/2022, wherein only one person, appellant number 1, was declared juvenile. Others, they could not produce any document, my lord. That plea has already taken.
My lord, I am proceeding. There are only 5 minutes, I will finish it. Now, my lord, I raised all these questions, the accused as much as, my lord, the accused as much as, my lord, accused number 1, accused number 2, accused number 3, accused number 6, accused number 7, accused number 10, and accused number 11, and accused number 12. 1, 2, 3, 4, 5, 6, 7, 8. Out of 12 accused, 8 numbers of accused were minor, at the time of occurrence, around 3, 4, 5, 6, 9, just 12.
Council, if the report is already there.
My lord,
This court has called for a report.
my lord,
The
that's
report
very
has come
I-
saying that only
I-
accused
my-
number one is a minor,
true, my
was
lord.
a juvenile.
My lord, I'm telling.
We don't need to go into this again.
That is only 1 minute, my lord. So in this respect, I file an IA. Not file an IA. I filed a case, my lord, in criminal. No, in same case, I argued, Honorable Commissioner Singh, Justice, ordered to file an IA. Thereafter, after I file an IA to prove that they are minor. IA I filed. Honorable Justice Sumon Shyam, Honorable Justice Arun Dev Chaudhary, my lord, IA criminal number 474/2021.
Yes,
IA criminal number 4. Please.
Order is there, 4/3/2022. Your
Yeah.
lordship may kindly have.
Kindly have a my lord, kindly have a look at IA. তোমার কথাই কই সময় এইটুকু তোমার কথাই কই সময় তুমি যখন কইছো ঠিকই কইছো তো IA criminal 474/2021. My lord, here, Honorable Justice Sumon Shyam and Narendra says, heard Mr. Richard Khan, my lord, heard Mr. Sanso. The application in the connected criminal has your lordship got order dated 22/11/2021. 22/11/2021.
Yes.
My lord, the application in the connected criminal appeal number 42/2020 were convicted under section so with section 114 of the IPC by the common judgment order dated 7/1/2020 passed by the learned session judge Karbiang Depot in connection with the case number so in sentence to entirely undergo rigorous imprisonment for life and also to pay fine with default situation. Aggrieved by the judgment and dated order dated 7/1/2022 criminal appeal number was preferred by the 12 appellants which is pending disposal before this court. During the pendency of the aforesaid criminal appeal, 8 appellant have filed IA criminal number raising on a plea of juvenile for the first time before the court of the appellate stage. By referring to the materials available on record, Mr. Khan has argued that it is self-evident from the statements of the applicant's record under section 313 CRPC that they were all minors on the date of occurrence, that is on 29/8/1996. And to such extent, the learned sessions that did not have the jurisdiction either to try or to convict any these of 8 applicants. Mr. Khan has therefore prayed for referring the matter to the Jurisdictional Juvenile Justice Board with a further prayer to release the 8 appellants on bail. Mr. Bhuiya, learned additional PP, has submitted that she would not in principle oppose the prayer to refer the matter to the Juvenile Justice Board for determination of age of 8 appellants, but no order releasing them on bail be passed to this court until a report obtained from the Jurisdictional Juvenile Justice Board. Having heard the submission of learned counsel for both parties and taking note in the scheme of the Juvenile Justice Board Care and Protection Children Act 2015, we are of the view that before passing any further order in matter, opinion of the Juvenile Justice Board as regards the claim of the juvenility of the 8 applications should be obtained by this court. We therefore direct that the Juvenile Justice Board Karbiang Assam would verify the claim of the juvenile of the applicants number 1, so all applicants, my lord. Since the appellants are presently lodged in the district of Jail Depot, Karbiang, we also direct the jail superintendent to make necessary arrangements for producing the aforesaid 8 applicants before the concerned Juvenile Justice Board. The London Juvenile Justice Board to notify the dates of appearance of the aforesaid appellants along with documents, if any required to be produced by them as proof of their age. Since the appellants are in jail, hence we are of the view that the exercise as directed by us should be considered as expeditiously as possible, and a report of furnished to the court as regards the findings of the Juvenile Justice Board within 30 days from date from the today ordered accordingly. Registered to communicate all this thing. So report has been called for, my lord. Report has been called for, and the report has come. The report has come after only they just, my lord, the report has come. We prayed for 8%. They only 1% has been considered a juvenile. My learned friend just told me, your lordship. But question is this: my prayer before your lordship is this: we just file IA, giving some documents of brutal list because they are Munda community, my lord, tribal community people, most of them did not go to school. So they do not have any school certificate. Only one Suresh Munda, my lord, he has got the school certificate. He produced the school certificate, and considering his age of the school certificate, he was considered as juvenile. And rest 18 persons did not produce any sort of school certificate. They have only produced the voter list. They only produced the voter list, and the Justice Jubilant Board did not consider the voter list, stating that it is not a cognate and authentic document. So that my learned friend has seen, and this is the report, my lord, I have got. Now my question is, therefore, one person, Suresh Munda, was bailed, my lord. Your lordship, I will have a look at. I do not have copy. Your lordship will see in a lordship order, my lord, order of the my lord, the order dated 4/3/2022, my lord. In this case, kindly have a look at. I do not have, my lord. Your lordship has order date 4/3/2022. I lost my copy, my lord. 4/3/2022. Order first by the Justice Honorable Suman Singh.
Yes.
My lord. So only one Suresh Munda, affiliate number 1, has been released, considering him that he is juvenile. And the rest case has not been considered on the ground that they do not have any school certificate. They only submitted. They only submitted in the report. It has come, my lord. They have already submitted some voter list for verification of their age, and that the voter list is not a cognate and reliable document. It is not authentic. So their case has not been turned down, and Suresh Munda had been considered. So the case actually, those persons are juvenile. But question is this: the case has been tried. That case has been tried with the juvenile people. The trial itself is illegal, my lord. Therefore, it's a my lord. Just my lord. Next, my lord. Page number. And so,
Lordship, may I strictly submit? Lordship, probably that IA has not been disposed of yet, your lordship. Earlier IA, is it disposed of? My lord, I have not checked, I'm sorry.
It's disposed.
Disposed of. He may file another IA, your lordship, because in absence of any document, your lordship, ossification may be done, my lord, ossification test by constituting a duly constituted medical board, my lord. In absence of birth certificate
That
or
opportunity was given in the last order. It says, be that dismay, so far, says support a report in so far as. However, a sealing decision finding of the learned JJB Karbi Anglo, insofar as the 7 applicants are concerned, Mr. Khan submits that the conclusion arrived by the learned board is not as per law.
my lord.
The learned counsel has, however, reserved his right to assail the opinion of the board on the above aspect in an appropriate manner and appropriate stage.
My lord, the court
That
has
was
given me
passed-
opportunity.
That was passed in February 2022.
My lord.
It's more than 1 year now. What have you done?
No, my lord, the court told me that this question may be raised.
Why are you raising now?
My lord, court has given me opportunity to raise the question in the appropriate time. It is,
In
I am just
appropriate manner and appropriate stage.
my previous stage. My
At
lord, I
this
am,
stage, now you're just, your intention seems to be just delaying the matter.
my lord, I thought that I should raise this question on hearing, my lord.
Then
So
you
I am
file
raising
a-
today.
Then you file a separate IA,
yes,
separate IA.
for conducting medical test.
No, only the hearing. I told the court also, my lord, shall I submit a separate IA, or I shall raise the question in at the time of due course of hearing.
Court cannot advise you what to do.
My lord, so my
You are
lord,
the
I am raising
counsel,
this question.
You are the counsel, you should know what to do.
Yes, my lord. I'm sorry, my lord, but I am raising this question today before your lordship. That the case itself completely, my lord, the tide has been made with them. One has been considered, my lord. And all are at the same age, my lord. One has been considered owing to that he has got the school certificate. The rest did not produce any school certificate, only they have submitted the bootal list. The bootal list, the learned JGB did not consider. So, my lord, this is just missing the one point, my lord, the tide has been made illegally. I am submitting in the during the course of hearing before your lordship. The tide has been made illegally. Suppose one person was juvenile, the tide has been wrong. One has been considered juvenile, and the order has been made, he has been released from jail also itself. My lord, that is for lordship note I am submitting.
It's up to you. You want to proceed, we'll proceed. In terms of the final order passed in the IA. If you want to take time and file some appropriate application
my
so
God.
that this court can help you out, that's a different thing. Otherwise, you want to proceed with the hearing, you can proceed. Now, there's already a judicial order of 4th
Yes.
2022.
My lord.
Beyond that, what can we do?
My lord, I thought that if I raise this
You
raise
thinking
this
is a
question before
different
the
thing, but you acting is another thing.
my lord.
How you reacted to this order of 4/3/22?
My lord, 4/3/2022. Order
You
dated.
did nothing.
My lord, I do not think to file a separate IA, my lord.
It's up to you.
I-
If you are not intended, then we proceed with the hearing.
Wait, my lord, wait, one. আসে নাকি? National road.
Only in the absence of
Police, my lord. Ossification test they have done, my lord. Now, this is point. Let me see, my lord. Yes, my lord, the 90 section 94 presumptions on determination of age, subsection 3, and only in the absence of 1 and 2, school certificate, provision of municipal authorities, and the above age shall be determined by an ossification test or any other latest medical age determination test conducted by the orders of the commission or the board. Ossification test, the report I have seen, my lord, they have done the ossification test. So it's by the report I have 4070
Ossification test was done.
was done, my lord. So far their report has come.
Hardly I have gone through the report, court's order, your lordship. Probably due to, as they did not place any document, your lordship.
My lord, that their report says, I am reading, the report says,
Where's the report?
report says, my lord, that I am giving.
What date is it?
Would word in their age, my lord. Report, my lord, dated, my lord, 4th February 2022.
What?
4th February, that is 4/2/2022.
Okay.
Their report says the ossification test was made. Bearing an ossification report, medical report bearing number above 40 years, disseminated to 50 years. By to all of my Sarah, it's actually a point. It is economy 200.
Where's the report?
This is the report, my lord. This is the report. Ossification report, my lord. Case record, it is available, I think. The JDB is sent to court also. A copy has been sent to me also.
Date.
Date, my lord, date, ossification date, that is report date, my lord, 4/2/2022. A report has come from JGB depot.
How does it start?
My lord, has your worship got this report? Or I must give a copy also. my lord. Okay. মই তো সেইকাৰণে এইটো উঠা নাই ৰেকৰ্ড আহি গৈছে দুই তিন পেজ আছে কিন্তু মই পেজটো পঢ়া নাই আৰু এটা মিছ গৈছে
I don't know. I'm just going through. Oh. Yeah. So,
আছে কেমন করে এসে হতে পারে লিখিলেও করে ঠিক টাকসাত তো চাইছে এইটাই
preliminary report. Then there's a report here. Could be this one. Report 2022.
Oh my god. A report has come. They have done the prosecution level also. They have tested teeth. I've seen. So I thought that this report is enough. No need to find another IA.
Yeah, that's it.
If I file IA, my lord will pass an order for a prosecution test and this. That part has been over. I've seen this report. 4/2/2022.
This one, no? So all of them are given.
Lordship, may I submit my note? On this report, this honorable court has already taken judicial notice of the matter. And on the last occasion, he has taken the plea, and liberty is given to him to challenge in appropriate manner, which he didn't do so, my lord. And the report.
1 minute,
Yes, your lordship.
Yes.
So your lordship, he again cannot reiterate his stand, take the stand of juvenility, your lordship. We should proceed with the merit of the case, my lord.
Have you got a copy of that report?
I have got one copy, my
I
lord.
misplaced it on, I have got it from him right now, just now, my lord. The
I've given her-
ossification test was done.
Ossification
Yes,
test
my
and
lord.
Brain, what we call, that was also done.
Yes, my
And
lord.
if you see the chart
Yes, my lord.
on the extreme right-hand side,
Yes,
remarks.
yes. 3 dates are mentioned because though on the basis of I card, voter I card, and ossification report. So there are 3 dates, my lord, 3 age. 14, 16, 21. So which one this honorable court will take? Because lordship identity card and voter I card is not a valid piece of evidence, your lordship, as regards to prove the juvenility, your
So
lordship.
we have to go with the medical report.
Yes, my lord. The medical report is 21 years after conducting ossification test.
Then the second one is 31 years.
Yes, my lord.
21,
Yes.
21.
So this report attains its finally, he did not challenge in appropriate forum.
370. পড়াশোনা মানে তোমার বিভিন্ন কথা। তোমার একবার তো তোমার ঠিক আছে।
So we go with this. Different.
Oh, my lord, by submitting all this, as much as 8 persons claim to be juvenile.
No.
8 persons we
As,
claim,
as per the ossification report,
my lord.
all of you are,
No, all of no, my lord. One has been released, my lord.
one was. found-
One person has been declared juvenile, and by this honorable court, he has got released bail and he is at home now, not in prison. So one person has been considered juvenile, only on the fact that he has got the school certificate. Report has come. Other, in respect of other, they have submitted voter identity card. That has not been considered.
That has been considered.
Voter identity card has not been considered, my lord.
Look at your report.
Why, my lord, kindly see report, my lord. Kindly see report.
Now the voter identity card and
Finding.
all this,
My lord.
this strong piece of evidence or the ossification report would be the appropriate.
My lord, kindly see report finding,
I've seen.
report finding.
Hmm.
Therefore, because what we have discussed above and also basing on the medical age, determination report, ossification others, and other documentary evidence stating age of the appellants, we arrived at a conclusion that appellants Rajan Munda, Rup Singh Munda, Mantu Munda, Deepak Munda, Marki Munda, Ganga Munda, and Dimon Munda were not juvenile on the date of commission of alleged office. However, say Suresh Munda, Suresh Singhu was juvenile on the date of commission of alleged offense. One has been considered. However, Suresh Munda was considered. But from 8 persons, 1 person has been considered 79.
This report stands.
My lord,
This IA was filed
my
by
lord,
you.
my
On the
lord,
basis of your IA, all these steps were taken.
my lord,
Report, we sent it down to the JGB board.
my lord.
They did whatever is required to be done. This report was submitted. On this basis, this IA was closed.
Closed, exposed.
That means this report of 4/2/2022 stands. What more do you want?
My lord, I want to raise this question because I have given opportunity to raise this question in
Have you raised the
appropriate,
question by way of an appropriate application
my
or
lord,
through your criminal appeal?
in appropriate period,
Can you
I should raise this question.
After this IA has been closed,
My lord,
in the criminal appeal, can you raise this question? You have to apply your mind.
no, my lord,
Don't waste our time now.
in IA, I have given opportunity to raise this question in the appropriate court of law. That is in hearing stage also.
Appropriate forum, appropriate, this IA has been disposed of along with the report.
No.
Report attains finality now.
My lord, my
What
lord.
do you do now?
My lord, your lordship see 4/3/2022 order in which court said that Mr. Khan has said that he says other 8%
Read
person
it
has not been
properly,
considered.
read it properly, read that paragraph properly.
In hearing stage, I have raised this question, my lord, for your lordship knowing, for your lordship knowing, my lord. For your lordship knowing hearing stage, I are raising this question. Court has given me opportunity by order dated 4/3/2020.
The learned counsel has however reserved his right
My lord,
to assail the opinion of the board on the above aspect in an appropriate manner,
my lord,
an appropriate stage.
my lord.
Now tell me.
So I'm raising it before your lordship also, my lord. I deem your lordship is an
I've
appropriate. court.
given you so many hints. I don't know. You don't understand anything.
My lord, my lord.
Can't you take some hints? This court cannot directly tell you do this, do that. We are giving you some hints. You don't understand. You don't accept those hints. What can we do?
Obliged, my lord, obliged. So, my lord, your lordship, at 2, my lord, I should.
No, at 2, we are going to have single bench.
My lord,
Single bench.
so my lord, then I am concluding my argument, my lord. I should finish it today. Because I will go to teacher, my lord, I will not be here.
Have you seen the watch? Have you seen the clock?
Only 5.
Do you know the timing of this court? After you conclude again, I have to hear the opposite side. I don't understand what is going on.
So, my kindly fix up a date, then my lord, short date, my lord, I am here. Short date.
Yeah, HR Khan.
Aisha Khan.
Heard HR Khan and the counsel for appellant, also heard MS B. Buyan and the additional to the Assam. When do you want?
Tomorrow, day after tomorrow, my lord. Because for this case, I mean, on that day, I told your lordship also, my lord. Kindly help me, my lord. On my Thursday, my lord, kindly.
On that day, you're going to raise this question again?
On Thursday, my lord, on Thursday.
On Thursday, are you going to raise this question of juvenile?
I will not, juvenile question I will not raise. My lord, I will not raise. I will not raise. Juvenile question I will not raise. Deeply obliged, my lord, I will not raise.
18th May.
18 minutes. Deeply obliged.
None appears for the applicant. List the matter again on 23rd.
Item 2, hearing.
A very short recapitulation regarding the issue. This is a writ petition challenging a termination of service of the petitioner who was serving as the university engineer of the Dibrugarh University after a disciplinary proceeding. But initially, when the disciplinary proceeding was held and then order of termination was served upon the petitioner, she had approached this honorable court.
Just a minute, he has filed an appeal, isn't it?
Yes,
She,
has filed an appeal.
before the
It
governor.
is pending before the governor,
When was it filed?
my lord.
Para 16 of your reply.
Yes. 1960 also filed in 19. April.
19/6/2018.
18.
What is the outcome of this?
My lord, it has not been disposed of till now, is my information. University has not been informed of any disposal. But tendency of the departmental appeal, this appeal has, this writ petition has been filed. Now, my lord, on the last occasion, I had suggested there'll be two ways out, my lord. One, in case the petitioner loses out in the writ petition, the appeal, my lord, would not
That
serve
would-
any purpose thereafter.
That would affect the appeal before the governor.
In case the appeal is allowed or it is dismissed, in case it is allowed, one of the writ petition would be infructuous. And in case the appeal is dismissed, that has to be again challenged. So, my lord,
That is not
pendency of,
been mentioned in the writ petition.
Writ petition, it is not mentioned, but appeal before the authority is mentioned. And kindly see one thing. This affidavit has been filed by the registrar of the university on, I have received, my lord, on 13/6/19. Please come to paragraph 34. I want to show you. Lord.
Which one?
My lord, one affidavit filed by the
Oh.
respondent one
That I will
on
show.
13/6/19.
that I will show,
This is important.
that I will show.
13/6.
6/19, an affidavit
Yes.
filed by the registrar of the university. My lord.
Reply copy to us, not a copy, reply.
I received the
Reply.
copy on 13/6/19. It will be 14 in that maybe filing. 14/6/19 maybe. Just have the copy on 13/6/19 to me.
13/6/19.
Yes, my lord. Affidavit by respondent number one.
Running page 286, my lord. Reply copy.
Wait, the 6 is something else.
286 is the page of my report.
Affidavit in opposition.
Yes,
Password nagi etu. August.
It starts at page 278, if I'm not wrong.
Mine is 287. It's filed on 29th October 2019.
ঠিক আছে না?
Is it correct?
By Dr. H.C. Mahanta, my lord, registered.
Ah, correct.
Yes, yes, this one. Please come to paragraph. This is, see the paragraph one. I am presently serving as the registrar of the Dibrugarh University. My lord, lordship is seen.
Yes.
Now, please come to last page, my lord, page number 9.
Yes.
Let me read this one, paragraph 34.
Hmm.
With regards to the contents of paragraph 60 of the writ petition, the answering deponent states that petitioner having not approached the appropriate appellate authority, her assertion that she had demanded justice and the same had been denied is erroneous and false, my lord. You'll be surprised, lordship will be surprised to know, my lord. Kindly take my affidavit. I reply filed on 11/9/19. This date is important. This was filed on 13/6/19. Kindly, my lord, then note this date, my lord. Now come to my reply, my lord. That was filed on 1/9/19. 1/9/19.
11.
1/9/19. 9/19. Yes, even 19. Lordship's got it, my lord.
Para 16.
para 16. And now please come to para page 7, my lord. Page 7. Page 7. Annexure A. Lordship has seen it, my lord?
Yes.
Annexure A. Dated condition right side top 6th of August 2018. This letter was addressed to the registrar Dibrugarh University. Lordship has seen this, my lord. To by whom? By D.J. Borkotaki, Secretary General, Secretary, Joint Secretary, Governor Secretary. Now see the contents. I am directed to forward here with a copy of the petition submitted by Dipali Fukon, University Engineer, addressed to the Honorable Governor Assam and Chancellor Dibrugarh University with self-explanatory. You are there on the above. You are requested to examine the matter and submit a pair-wise report thereon within 2 days of receiving this letter for onward transmission to this Honorable Governor of Assam and Chancellor University. This for you can inform necessary action. I want to say, my lord, the registrar has received this letter on 6th of October 2018. And he filed affidavit before this court in 2019, 3019. And what he says? What he's saying? Look at the statement in paragraph 34. Having not approached the authority, her assertion that she has demanded justice is erroneous and false. Is it correct on the part of the registrar, my lord, to make a statement before this court like this? Where is he knows governor has led this letter to him about this appeal?
Yeah, Majumdar, something is
My
going on.
lord,
Now-
I will answer to all of them. I'll answer to all of them. Let me finish. When I started, my lord, therefore I waited. I'll answer. Should I answer?
No, the
Lordship
issue is this, Majumdar and Mr. Nath.
Fine.
If there's an appeal pending, should we take this exercise? or not?
Factually, if an appeal is pending, my lord, that was my whole submission. That is why I had pointed out that there is an
Take
appeal
up this
pending.
Exercise.
Now, lordship we should either this writ petition should be closed as a premature writ petition, allowing the appeal to be disposed of, giving you liberty to come back. Or he gives up the entire appeal. And it is decided in a writ petition. It has to be either of the two, my lord. We cannot have two forums going on at the same time. Now, my lord, the assertion that the registrar, even knowing that there is an appeal pending, has filed an affidavit, and it is very wrong on his part. Lordship will allow me to go through the entire writ petition once. Page 37, para 59. The petitioner does not have any other alternative, adequate and efficacious remedy, is this statement made. So
No,
even that is wrong.
part
No,
is
we will not
already-
go,
Oh,
I do
right,
not
my
want
lord,
to
in
go
the petition-
personal on it. This appeal, there is no statement saying that it has gone through the registrar of the university. He annexes a letter, she annexes a letter saying that a joint secretary has written to the registrar of the university. Where is the proof that we received it at all? These kind of allegations for a particular disciplinary proceeding, my lord, on a particular person who has sworn an affidavit in his official capacity. My lord, I do not know. I have my reservations on that. Pointing out small things like this. Not small. We start picking up on the
Whatever
repetition,
it
it will
is,
be
whatever
difficult.
it is,
We don't go into that.
only issue is that appeal which you have
My lord,
admitted.
yes.
Yes.
You have admitted in your reply.
Yes. Yes, my
It was filed on 19/6/2018. or
Yes.
something like that,
yes,
if I'm not wrong.
yes. 1918.
What is the stage of that appeal? Has it been?
My lord, nothing has happened because we filed the appeal on 1918, 6/18, the letter is there. Thereafter, my lord, filed the writ petition of 5/9/18 after 6 months. How long a person who has been terminated now has been retirement age has gone, my lord, in the age of superannuation, the person will wait. After nothing has happened in the appeal, she has filed this case, my lord, honorable court, my lord. How long? Suppose they don't feel that they dispose of this appeal for 6 months or 6 years, 5 years, a person, citizen will wait. I don't think lordship will allow the citizen to do that, my lord. Take exercise under Article 226. Even till today, nothing has happened. And this is the letter addressing them, what they have done. Let me say so, what they have done. Have they
No,
furnished the
I am not supposed to do.
inspection?
The appeal is to the governor, my lord. The
No, no.
appeal is to the governor, not to the university.
The joint secretary governor
It is the governor who is going to decide the appeal.
has sent down the letter to you.
To us. We have sent the records. Now it is upon the appellate authority to do what it.
Have you sent a record?
Yes. We do not keep the records with us. We have made the official copy of a record. It has all gone to the governor. We do not hold back things, my lord.
Original copies with them. This is
Has to
original
be.
copies.
Has to be unless the originals are caught. Lordship will see the letter which the governor secretary has written. I am directed to forward herewith a copy of the petition submitted by so and so at page 7 of the affidavit, addressed to the Honorable Governor. On the above, you are requested to examine the matter and submit a parawise report thereon within 2 days of receiving this letter for onward submission to the Honorable Governor as desired. Where is the requirement of my sending the entire records? There was no request to send a record. But either we concentrate on the merits of the case, or we concentrate on trying to malign the officials or in an attempt to swerve off the main issue. This appeal, this letter comes on August 6, 2018. Writ petition is filed on 5th of September 2018.
18, after 3 months.
3 months. 3 months, no appeals are, my lord, in what I have seen when I have seen through the files, my lord, appeals are not disposed of within 2-3 months. At least a statement in the writ petition, I have filed an appeal, it is pending, I am frustrated, allow me to prefer the writ petition, nothing. The appeal is completely kept silent. Till the time the registrar comes up to say, you have not preferred an appeal, there is a scope of an appeal.
But by the time
You
he
should have
knew, he
preferred
said
one.
there. How come he says so? He is placing before the lordship statement swearing. No appeal.
I do not know. Is it through me?
Equally is guilty.
The appeal copy is not placed before this honorable court, my lord, to show that it had gone through the register of the Dibrugarh University. And he had any knowledge of the petitioner preferring an appeal from the petitioner. Letter from the deputy secretary received or not, I can get the records. That is another aspect of the matter. That will open up a Pandora's box. But here at this stage, whether there was a statement that an appeal has been preferred, that being kept hidden. Not one statement.
Records.
That paragraph 34 is in reply to paragraph 60, which says
That I've seen,
it doesn't speak of an appeal. It says
that there's no efficacy.
for the hands of justice. That I am replying to that. The registrar is replying to that. The registrar is not replying.
Keep that aside.
We'll keep that aside.
We are not going into all this.
So therefore, my lord, on merits of this writ petition, the written arguments are before lordship. There is no allegation that there is any procedural flaw. That was the allegation in the earlier writ petition. We were required to give her an opportunity before passing orders on, first, before coming to the determination of her guilt, and secondly, while determining her punishment. We have followed it accurately as the court desired, and it was also accurately as the discipline and appeal rules required. The entire arguments are based upon saying that the evidence has not been properly evaluated. This evidence has not been taken into record. While appreciating this evidence, a wrong line of thought has been taken. I'll place just 3-4 judgments of the Honorable Supreme Court. What a petitioner can pray before this Honorable Court under Article 226? To what extent the Honorable Court would like to interfere in such disciplinary matters? If there is no procedural flaw alleged, if the principles of natural justice is followed, and there is no allegation that I was not heard, and my lord, lastly, if there is no allegation of malafide, matter ends. This is not a court of appeal. Therefore, the departmental appeal. So, lordship, in my humble summon, there are 2 courses of action: await the appeal, or writ petition be decided, liberty to see whatever happens in the appeal. And that would be a preposterous matter of submission, because once this Honorable Court decides a matter, the appeal would become infructuous and so on. And therefore, perhaps knowing that the appeal would not survive a writ petition without mentioning the appeal. I'll just place a few judgments. The extent to which this Honorable, I am not going into the evidence that has been laid. I'll just show where we have been correct and what cannot be argued by him. My lord, this should be (2029) SCC 471.
2000.
29 9 SCC, my lord, at the top in the Supreme Court of India, 1, 2, 3, fourth line from the top. Towards then, lordship will find 2029 SCC, 471 is the SCC citation. 3-judge bench, my lord.
Yes.
Lordship may like to have paragraph 25. I'll try to keep it as short as possible. Paragraph 25, somewhere at page 12. Lordship may remember, my lord, all the evidence was read on previous occasions. Para 25, page 12. Scope of judicial review in service matters. Learned counsel for the appellant spent considerable time taking us through the various evidences on record with the intention of highlighting lacunas and contradictions. We feel that such an exercise was in vain, as the threshold of interference in the present proceedings is quite high. The power of judicial review discharged by constitutional courts under Article 226 or 32, or when sitting in appeal under Article 136, is distinct from the appellate power exercised by a departmental appellate authority. It would be gainsaid that judicial review is an evaluation of the decision-making process and not the merits of the decision itself. Judicial review seeks to ensure fairness in treatment and not fairness on the conclusion. It ought to be used to correct manifest errors of law or procedure which might result in significant injustice, or in case of bias or gross unreasonableness of the outcome. Government of Andhra Pradesh versus so-and-so interpretation. These principles are succinctly elucidated by 3-judge bench of this court in BC Chaturvedi versus Union of India in the following extract. Judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives a fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. When an inquiry is conducted on charges of misconduct by public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer, whether the rules of natural justice are complied with, whether the findings of the conclusions are based on some evidence. The authority entrusted with the power to hold the inquiry has jurisdiction, power, and authority to reach a finding of fact or conclusion. But that finding of fact must be based on some evidence. Neither the technical rules of Evidence Act nor of proof of fact or evidences as defined therein apply to disciplinary proceeding. When the authority accepts that the evidence and the conclusion receives support therefrom, the disciplinary authority is entitled to hold that the delinquent officer is guilty of the charge. The court or tribunal in its power of judicial review does not act as appellate authority to reappreciate the evidence or to arrive at its own independent findings on the evidence. The court or tribunal may interfere with the authority held the proceedings against the delinquent officer in a manner inconsistent with the rules of natural justice or in violation of statutory rules prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding be such as no reasonable person would have reached, the court tribunal may interfere with the conclusion or the finding and mold the relief so as to make appropriate to the facts of each case. The disciplinary authority is the sole judge of facts. Where appeal is presented, the appellate authority has coextensive power to reappreciate the evidence or the nature of the punishment. In a disciplinary inquiry, the strict proof of legal evidence and findings on that evidence are not relevant. Adequacy of evidence or reliability of evidence cannot be permitted to be canvassed before a court or tribunal. In Union of India versus H.C. Goel, this court held at paragraph 70, at page 278, that if the conclusion upon consideration of the evidence reached by the disciplinary authority is perverse or suffers from patent error on the face of the record or based on no evidence at all, a writ of certiorari could be issued. Next, lordship would come to page 33. The 27, my lord, that it has been reiterated time and again. Para 28. It is thus well settled that the constitutional courts, while exercising their powers of judicial review, would not assume the role of an appellate authority. Their jurisdiction is circumscribed by limits of committing errors of law, procedural errors leading to manifest injustice or violation of principles of natural justice. Put differently, the judicial review is not analogous to venturing into merits of a case like an appellate authority. Thereafter, my lord, paragraph 33 at page 17. There was one ground sought to be taken that a criminal case was also started and there were certain evidences led there which could have impacted the disciplinary proceeding hearing. Statements given, evidence given in the criminal proceedings were not taken into consideration by the disciplinary authority or the inquiry officer while conducting the inquiry. That was one of the grounds taken. This will be answered here, my lord. Para 33, just above that, effect of criminal inquiry on disciplinary proceedings. The incident of so-and-so raised serious questions of criminality under Indian Penal Code and the Prevention of Corruption Act, as well as a violation of service regulations and administrative misconduct. Thus, in addition to appointment of inquiry officer, the authorities also registered a criminal complaint with the CBI. After investigation, the CBI, though did not find adequate material to lodge criminal prosecution against the appellant, but through its self-speaking report on so-and-so, the CBI recommended major disciplinary action against the appellant and a few others. It is beyond debate that criminal proceedings are distinct from civil proceedings. It is both possible and common in disciplinary matters to establish charges against a delinquent official by preponderance of probabilities and consequently terminate his service. But the same set of evidence may not be sufficient to take away his liberty under our criminal law jurisprudence. Such distinction between standards of proof among civil and criminal litigation is deliberate. Given the difference in stakes, the power imbalance between the parties, and the social cost of an erroneous decision. Thus, in a disciplinary inquiry, strict rules of evidence and procedure of a criminal trial are inapplicable. Like, say, statements made before inquiry officers can be relied upon in certain instances. Para 35. Thus, the appellant's contention that he should be exonerated on the present proceedings as no criminal charge sheet was filed by the CBI after inquiry is liable to be discarded. The employer always retains the right to conduct an independent disciplinary proceeding irrespective of the outcome of the criminal proceeding. Furthermore, CBI report does recommend major disciplinary action against the appellant. The said report also buttresses the respondent's case. In this case, the criminal inquiry had been initiated. Evidences were laid. So this is not a case in the CBI. In this particular case, the CBI had said, we do not want to go for a criminal trial. You do what you want in a disciplinary. In this particular case, charge sheet was filed by the investigating authority. It is one step ahead. So it's saying that evidence should be taken into account, but this has been negated. Even when criminal proceedings are not there, statements made before the inquiry officer can be taken into account, is what I understand. Then Lordship will like to have paragraph 36. That is regarding to punishment and plea of leniency. Though not so specifically, my lord, given or taken. Lordship will have paragraphs 37 for a moment. Paragraph 37 on the next page. Applying these guidelines, Lordship has, to the facts of the case in hand, it is clear that the punishment of dismissal from service is far from disproportionate to the charge of corruption, fabrication, and intimidation, which have unanimously been proved against the appellant. Taking any other view would be an anathema to service jurisprudence. If we hold that systematic corruption and its blatant cover-up are inadequate to attract dismissal from service, then the purpose behind having major penalties, which are explicitly provided under Article 311 of the Constitution, would be obliterated. Here, the allegation was, my lord, that work orders were executed without calling for tenders. The amount of earth filled was not being measured and full bills were being paid. There was a requirement of cutting down 12% of the total bill for shrinkage, etc. That was not maintained. Level books were not maintained. Nothing was maintained. So this is why I want to say that even the punishment which has been imposed, this honorable court has said, the Honorable Supreme Court has said, yes, it is for those occasions that these punishments are made for, even in Article 311(1) of the Constitution of India. Then Lordship would like to have the next, my lord. Then Lordship would like to have equivalent citation. I have not been able to find, but this is Civil Appeal number 7939 of 2022. Decided on 23rd of November 2022 by the Honorable Supreme Court, my lord, by the Chief Justice and Hima Kohli Judge, my lord. If Lordship should have paragraph 15. Paragraph 15 at page 9, my lord, down below.
Yes.
It is well settled that courts ought to refrain from interfering with findings of facts recorded in a departmental inquiry, except in circumstances where such findings are patently perverse or grossly incompatible with the evidence on record based on no evidence. However, if principles of natural justice have been violated or the statutory regulations have not been adhered to, or there are malafides attributable to the disciplinary authority, then the courts can certainly intervene. In the above context, the following are the observations made by the three-judge bench of in the BC Chaturvedi Supra. That is already I have read matter in the early judgment. Then Lordship would like to have paragraph 22. My lord, in fact, my lord, the paragraph paragraph 18 also, my lord, 18. Paragraph 17 and 18 and paragraph 19, my lord, they broadly lay down the circumstances when a court matter exercising Article 2, powers under Article 226 would like to interfere. If I'm allowed to read my lord, page 13, paragraph 19, laying down the broad parameters within which the High Court ought to exercise its power under Article 226 of the Constitution of India in matters relating to disciplinary proceedings. A two-judge bench of this court in Union of India versus others in P. Gunasekaran held thus. Despite the well-settled position, it is painfully disturbing to note that the High Court has acted as an appellate authority in the disciplinary proceedings, reappreciating even the evidence before the inquiry officer. The finding on charge 1 was accepted by the disciplinary authority and was also endorsed by the Central Administrative Tribunal. In disciplinary proceedings, the High Court is not and cannot act as a second court of first appeal. The High Court, in exercise of powers under Article 226-27 of the Constitution of India, shall not venture into reappreciation of evidence. The High Court can only see whether inquiry is held by a competent authority. The allegation in this particular case is not that it was not held by a competent authority. The inquiry is held according to the procedure prescribed in that behalf. Earlier repetition, my lord, we had a procedural lapse that was corrected. There is violation of principles of natural justice in conducting the proceedings, no allegations of that sort. The authorities have disabled themselves from reaching a fair conclusion by some consideration extraneous to the evidence and merits of the case. The authorities have allowed themselves to be influenced by irrelevant and extraneous considerations. The conclusions on the very face of it is so wholly arbitrary and capricious that no reasonable person could have ever arrived at such a conclusion. The disciplinary authority had erroneously failed to admit the admissible and material evidence. The disciplinary authority had erroneously admitted inadmissible evidence. Finding of fact is based on no records. Under Article 226 of the Constitution, the High Court shall not reappreciate the evidence, interfere with the conclusions of the inquiry in case the same has been conducted in accordance with law, go into the adequacy of the evidence, go into the reliability of the evidence, interfere if there is some legal evidence on which findings can be based, correct the error of fact, however grave it may appear to be, go into proportionality of punishment unless it shocks the conscience. And Lordship would like to have para 22. To sum up the legal position, being fact-finding authorities, both the disciplinary authority and the appellate authority are vested with the exclusive power to examine the evidence forming part of the inquiry report. On finding the evidence to be adequate and reliable during the departmental inquiry, the disciplinary authority has the discretion to impose appropriate punishment on the delinquent employee, keeping in mind the gravity of the misconduct. However, in exercise of powers of judicial review, the High Court, or for that matter, the tribunal, cannot ordinarily reappreciate the evidence to arrive at its own conclusion in respect of the penalty imposed unless and until the punishment imposed is so disproportionate to the offense that it will shock the conscience of the High Court and is found to be flawed for other reasons as enumerated in P. Gunasekaran. If the punishment imposed on the delinquent employee is such that it shocks the conscience of the High Court, then the disciplinary authority may be called upon to reconsider the penalty imposed only in exceptional cases which need to be mentioned should the High Court decide to impose appropriate punishment by itself on offering cogent reasons applying. On applying the law laid down to the above instant case, we are of the view that the High Court ought not have interfered with the findings of fact recorded by the disciplinary authority. Charge number 1 legal against the respondent pertain to negligence in dereliction of duty attributed to him for having failed to prevent theft of so-and-so cases of copper, so-and-so. This particular case has been discussed. Thereafter, if permitted, my lord, the matter of him Singh, my lord, reported in AIR 2020 Supreme Court 5455. Para 33, if Lordship would have. There are other relevant portions, my lord. I would just read para 33.
Yes.
That Lordship would find at page 28, 33, at page 23, my lord. Page 23. In exercising judicial review in disciplinary matters, there are two ends of the spectrum. The first embodies a rule of restraint. The second defines when interference is permissible. The rule of restraint constricts the ambit of judicial review. This is for a valid reason. The determination of whether a misconduct has been committed lies primarily within the domain of the disciplinary authority. The judge does not assume the mantle of the disciplinary authority, nor does the judge wear the hat of an employer. Difference to a finding of fact of the disciplinary authority is a recognition of the idea that it is the employer who is responsible for the efficient conduct of their service. Disciplinary inquiries have to abide by the rules of natural justice, but they are not governed by strict rules of evidence which apply to judicial proceedings. Standard of proof is hence not the strict standard which governs a criminal trial of proof beyond reasonable doubt, but a civil standard governed by the preponderance of probabilities. Within the rule of preponderance, there are varying approaches based on the context and subject. Number of, in all these cases, Lordship would find that when a disciplinary process is challenged, the reappreciation of the evidence on record. In this particular case, my lord, there was an inquiry committee headed by a senior advocate. That committee found the petitioner guilty. Matter was placed before the EC, the Executive Council, which is not comprised of one person or of any persons who are from within the university alone. The Executive Council, my lord, consists of members from all over India. Opportunity was given to the petitioner to know all the evidence before him. She had the opportunity of cross-examination, of defending herself even by giving her evidence, others' evidence. Everything was allowed to her. Thereafter, the reasoning was reached that she was guilty. The EC gave her the opportunity of, prior to coming to a conclusion that yes, we agree with the inquiry report. Inquiry report being upheld, the delinquency being held to be correct, she was given an opportunity to say what she wanted to say against the proposed punishment. And thereafter, the punishment was imposed. Coupled with the fact that an appeal was filed. For the Honorable Supreme Court, the appellate authority is quite capable of looking into every piece of evidence because it is an appellate authority. You can reinvestigate everything. In such circumstances, this writ petition does not need consideration of this Honorable Court, in my humble submission. When on the last occasions the evidence was read, or when I had read the different orders which are passed against the petition, Lordship may appreciate, my lord, the evidence part was argued upon. The power of the authorities, the absence of principles of natural, nothing was placed before this court. It was only that this evidence not appreciated, that evidence not appreciated. Honorable Supreme Court has said no, that will not be taken into account under Article 226, unless it is of such an extent that a reasonable it will not a reasonable man will not appreciate. It has to be of that extent. In this particular case, it is not so. In my humble submission, my lord, pendency of the appeal itself should be a ground for dismissal of this petition with liberty to approach again once the appeal is decided. There is no difficulty. If there is some mistake in the appeal, my lord, some procedural mistake, anything, my lord, there's always this Honorable Court which can look into it. But at this stage, with the judgments of the Honorable Supreme Court saying that interference is not called for, no relief can be granted to the petitioner at this stage. Unless some gross procedural aspect is now put forward, to which I will have to reply. The written arguments, my lord, I have seen, doesn't say that there is a procedural lapse. So if something new is argued, my lord, I'll have to answer to that. Otherwise, chance in the appeal. The writ petition is decided, the appeal has to be The appeal cannot be gone ahead with the appellate authority. Even if it is even if it is by the governor, my lord, ultimately the writ petition being decided, the appeal has to become infructuous. Because at that point of time, the honorable governor would be acting only as an appellate authority, not as the governor of the state.
5 years running. 5 years running appeal file. 18, 19, 20, 21, 22, 23. Many will wait. Lordship will never allow that.
That would be for the office of the honorable appellate authority to reply to, my lord. I, as the disciplinary authority, I represent the disciplinary authority.
No,
I am not in a position to comment upon the actions or inactions of the appellate authority, so called. That would be beyond my brief.
Yes.
In fact, the appellate authority is not even a party, so far as the appeal is regarded. So far, he is the chancellor of the university, my lord, that I'll have to see, but otherwise, my lord, he's not even in the capacity of an appellate authority, he's not here, my lord. I'm correct. my lord. The appellate authority has not been brought in. The intent not to let this court know of an appeal. Four parties. There is no governor. There is no chancellor. There is no governor. In case, my lord, some other procedural aspects are argued, my lord, I'll then show from the rules, and I'll just refer to the rules to show that this is what we have followed.
Yes. My lord. One thing, my learned, I'm grateful to him. He has alerted me on one point particular, my lord. He said, so far as judicial review is concerned, your lordship may not and shall not represent the evidence. On this point, my humble submission is, if there is appreciation of the evidences, then the question comes whether lordship will reappreciate it or not. Suppose there is not even appreciation, that you don't even look into it, nothing was written about that in the pin order, in the decision, then what? It is reappreciation. If I point out to your lordships, no. My submission is no. If there is an appreciation, then yes, I am barred. I cannot say lordship can look into it. But if there is no appreciation, can there be appreciation? That's what I want to show your lordships, my lord. Now, my lord, I have given one judgment, my lord, 2020 SCC online, SCC, my lord, name of the party, State of Rajasthan and others. Last occasion by Honorable Justice D.Y. Chandrachud and Indira Banerjee, my lord. Like this. In a go. So 2020 SCC online, like this it will be. Front page is like this, my lord. Like
Yes.
my lord, please come to paragraph 39, page 16. From the last side, my lord, page number 4. Para 39. Lordship has got it, my lord?
Yes.
Can I, this paragraph, this part and the second part in the next page, let me read this much, my lord. This is about exactly about this point. Or in short, I can take a lordships to the next page. Next page, then I can. At the other end of the spectrum, I think, my lord, shall I read from the first? As your lordship, please. I don't.
Otherwise, we have read this.
Yes, that's right. Yes, let me just point out. Yes, let me point out this one. Yes. At the other end of the spectrum is the principle that the court has the jurisdiction to interfere when the findings in the inquiry are based on no evidence, or when they suffer from perversity, A failure to consider vital evidence in an incident of what the law requires as a perverse determination of fact. That is the what. Proportionality is an entrenched feature of our jurisdiction. Service jurisprudence has recognized it for long years in allowing for the authority of the court to interfere when findings or the penalty are disproportionate to the weight of the evidence or misconduct. Judicial craft have been termed as the two ends of the spectrum. Judges do not rest with a mere recitation of the hands-off mantra when they exercise judicial review. To determine whether the findings in a disciplinary inquiry is based on some evidence in an initial or threshold level of scrutiny is undertaken. That is to satisfy the conscience of the court that there are some evidence to support the charge of the conduct and to guard against perversity. That's what, my lord. Now, why I said so? The reason is, my lord, in the disciplinary inquiry, there is an official witness. His name is Sanjeev Sharma. He was official witness, my lord. He was a accounts officer of the department. Now, please come to page 192. See his evidence. Just have a look once, my lord. Page 192. My 192. I am the employee of the Juvenility University working as assistant registrar. I have come then third para. I was promoted to the post of accounts officer. Even after my promotion to the post of accounts officer, I was discharging the duties of the divisional such. My lord, please come to the next page. That is important. Next page. Continuation. That's important. I used to be present in the PNC board meeting, purchasing committee meeting, board meeting, this, my lord, to assist the officers with records. I remember that in such meeting, when the discussion took place regarding the construction of the building of the Jet campus, the then Vice Chancellor rigorously insisted that works must be completed as early as possible so that the students can occupy those buildings by the start of the new session in the month of August 2011. The wish of the Vice Chancellors, as aforesaid, was appreciated by all the present in the meeting as well as the university students. Accordingly, the work was sought to be completed at a faster pace. I was not involved in completing the process of execution of the work in any way, and my duty was only to check and forward the bills when those came before me. The then Vice Chancellor, that's important. The then Vice Chancellor, who happened to be the chairperson of the PNC board, used to issue verbal instruction to the university engineer to immediately start the work, including connected earth filling works, through the contractor who has been chosen for carrying out the construction of the building. The Vice Chancellor himself at times instructed the contractor who have been allotted the works to go ahead and start the work immediately without waiting for the formal orders. That is the case here. In a meeting, because time was short, the Vice Chancellor on good faith actually, my lord. That's what he done. He said, start the work immediately. Normally, sometimes it happens, my lord. Work order you will issue later on, my lord. What the work? Because days are numbered. Summer will come, rain will come. This is the reason it happened like that, my lord. Lordship has seen, it is the instruction of the Vice Chancellor. There's the reason. In page number, my lord, 199, Lordship will see the work order. I issued the work order later on. This is the instruction, the work started by the contractor. Even, please come to page number 28, my lord. See the evidence of one of the contractor, page number 28 of this petition.
Wait.
Only 28.
Yes.
My lord. Just I'll show to you, my lord. This is the position of the events witness number 6. He's one of the contractor. His name is Manoj Guhai. What he says, about 1 month prior to the issuance of this work order, I was verbally asked by the then Vice Chancellor of the university to execute the work, and on the basis of that verbal instruction of the Vice Chancellor, I started the work. I was asked to do the work verbally because I, being the lowest bidder, was selected for doing the construction work of hostel number 2, for which I received the work order dated such. In the cross-examination stated that entire work was completed within 40 to 45 days, and the work was started prior to the receipt of the work order, and on the strength of the receipt of the verbal order of the dead Vice Chancellor of the university. That's the case, my lord. Now, even the registrar of the university, in evidence, in a criminal case, in defamation case, he said, in page 274, he said, we issued as a work order as a supply work. He said, I have annexed here, my lord, that I have given him a written argument, it is their lordship file, I will not trouble your lordships. Now, one more thing I have to bring to your lordship's notice, my lord. What is this entire case? What is happening with this case? I issued the work order, true work order, that there should be art filling work. Allegation charged against me is that there is no approval by the PC board. Number one. Number two, my lord, there is no sanction. Lordship will find, my lord, in this inquiry report, the PC board approval is there. I think it's in page number 109. Approval is there. Even approval here also, it is approval there, my lord. I can show it to your lordships, my lord. Just a second. Approval is there, my lord. Page 190, please come, my lord. 190. 190. Approval.
Yes.
Resolution number 32. Resolve that estimate of 16 lakhs such and such number building be approved. Resolve further that exhibit shall be made from the such structure department, at least feet on top will be art filled. B also same thing, my lord. It is B, and resolution number 33. Same thing, kindly see the last word, be approved. So approval is there. Even the inquiry committee, my report, lordship will find, my lord, that is there, my lord. Approval is there, my lord. No doubt about it. Now, to make it little shorter, my lord, please come to one page number 43. The basic issue is here, page 43. Charges. 43, only 43.
Yes.
This charge number 1, it says 1, 2, 3, 4, 5th line, my lord, can you see? If dishonestly, 5th line from top, and without any sanction from the competent authority, allotted 2 numbers of art filling work, lordship is seen in page number 90, there is the approval. So this goes. Charge number 2. Second line, you illegally issued work orders numbers such and such without following due procedure allotment of contract work. Lordship has seen the evidences, 2 evidences. Vice chancellors, do it. This also goes. Next, 3, issuing work orders by artwork to contractor without taking prior approval from the authorities. My lord, lordship has seen in the evidence, their evidence, they say the contractor who construct the building, it is given to them also. Only you fill up this and construct the building. That's the minimum practice there, my lord. Now, this is my part. Now, one simple order, lordship, may kindly have a look at my page 199, 98, page 198. Just a simple, I'll show you the lordship, my lord. Why I have been only targeted, my lord. 198. Lordship has got it, my lord.
Yes.
See, this is issued by me, 21/3/2011, bottom, my lord. Lordship is in the date, top also this is the date. Office of the Registrar, Dibrugad University, to Raj Kamal Das, contractor, development of construction site for the aforesaid construction of the hostel number 2 building. Dear sir, this is important, my lord. You are requested to supply the following materials in consultation with Mrs. D. Fukan, me, university engineer. Then description, kindly see, raising low site around the building with appropriate soil. Lordship has seen, my lord, this writing. In the middle, lordship will find if any monopoly, etc. Profile measurements to be taken and 12% deduction of sinkage. This is also written here. Now, my lord, and the after this paragraph, bold letter, my lord, rupees 16 lakhs only approved. See, this approval also is there. Now, next page, 2 orders. Can we come to next page? Same exactly. 21/3/11, second order I have passed. Everything same, my lord. Now, this is I passed as an university engineer. Please come to my lord now, page 10276. Just see. Similar order was passed, my junior engineer. Absolutely nothing has happened to him, my lord. Because this is a system of the university, my lord. Now, who I have been targeted, and that's called hostile discrimination, my lord. Please, this 276. Lordship may keep one finger in page number 199, please, my lord.
Hmm.
276. Kindly see the 198 or 19, any page, Lordship may take. See the language. To Manoj Guhai, by whom? Assistant university engineer. My lord, he was my junior. He issued the same work order, absolutely same, no difference. Wordings kindly see. You are requested to supply the following materials immediately in consultation with, here you are requested to supply the materials concerned with D. Fukon, and there it is his name, Prashanta Sharma. Everything same. 12% rejection, everything same. Now here, absolutely nothing happens, my lord. He follows the university system. There is a barber instructor to the vice chancellor. He does it. When I did it, my lord, now there's a entire heaven has fallen, my lord. Why two guidelines for two persons? It should be the same thing, my lord. When I do, everything has been broken. All the law, and I have done such a blunder. When this man he does, he did nothing happens, my lord. This is why I say the charges Lordship has seen, my lord. They say there's no approval. There's the approval. Inquiry report in page number 130, Lordship will find, my lord. It is there. 130, please have a look. 130 page number. Inquiry report. It start page 129 bottom. Page 129 bottom. Observation of the inquiry officer, my lord. From the materials record and the evidence adduced by the parties before us, we have noticed certain aspects in general which we would like to place here and there. The PC board is the statutory authority of the university and vice chancellor is the chairperson of the board. PC board retains the authority to monitor and supervise all types of construction works of the university. 2. The university engineer is the executing authority and is responsible for execution of all types of contractual works under the control and supervision of the PC board. 3. PC board approved 2 works involved in this inquiry for execution of 8321. And what is the charge number 1? There is no approval. There is no sanction. Just have a look at this. In this paragraph, my lord, see the last line in this paragraph, paragraph 3. However, there was no decision for the PC board that the APWD code should be followed for all contract works. Now, kindly see serial 5. The copies of the work orders so issued by the university engineer were appeared to have been forwarded to the vice chancellor and the registrar and the account section of the university. However, none of these authorities raised the point as to how the work orders could be issued without resorting to the tender process and what basis the contractors have been chosen by the university engineer. This shows there's a lack of vigilance on the part of the higher authorities. Next page, my lord, kindly come to next page and see the conclusion there. Next page, in the middle. We are therefore constrained to hold that there were lapses on the part of the finance accounts branch of the university as well as the interior auditor. At the same time, there's a lack of proper vigilance on the part of the office of the registrar of the university. Now, suggestion. For the proper functioning of the PC branch of the university should issue circulars laying down guidelines detailing the procedures to be followed for in the execution of contractual works, right from the point of preparation of the estimates till the payment of bills. These are this. B. University authority may appoint, engage even on temporary basis an officer who is an expert in execution of the civil construction works for guiding the present staff of officers of the university. The university authority may also make provision for giving training to the employees of the PC branch to educate them regarding the proper procedure for the implementation, execution, and supervision of civil construction work. Next page, my lord. Little. 3. The university authority should also issue orders specifying the duties and responsibilities of the university engineer and other staff of the PC branch for better accountability and smooth functioning of the branch. The authority may have a relook to the office order dated such and such in this regard. Similarly, for the finance accounts branch of the university also, appropriate guidelines should be issued regarding processing the contractor's bill and release of payments thereon. Steps may be taken to impart proper training to the officers of the branch. We make these suggestions because we have learned that during inquiry, that because of lack of specific rules, guidelines, laying down the specific procedure for execution of the works, passing of bills, there is no uniformity in executing various works and the officers are left to guide themselves of their own whims. That's what, my lord. The lordship has seen, my lord, for this type of work. What has happened to me? First, they suspend me. I came before your lordships, my lord. Lordship set aside, go and join. I went there, I joined. Again, they suspend me. Again, I came to lordships, my lord. Again, they suspend me. Again, I came to lordships, my lord. There's a proceeding. In the proceeding, again, they have removed me. I came the third time. This is the fourth occasion I came. Now, lordships believe, unless there is some strong order from your lordships, my lord, if everything lives on them, will they allow me, my lord, to join? They will never do it. This is the fourth occasion I came before this honorable court, my lord. In my list of dates I've given, how many times suspension? 29/4/14 suspension, 6/5/14 honorable court set aside in a direct of reinstatement. Again on 30/5/15 I was in suspension. Honorable court again came to my rescue on 19/5/16. Then inquiry committee. Then again they terminate me. Again honorable court set aside. This is the fourth occasion I have come, my lord. My lord, the lady has got tired, my lord, of these illegalities, my lord, and hostile discrimination, my lord. While everything was pending, she has retired, my lord. And now that she's running, taking her husband to the Chennai Apollo Hospital and coming back, my lord. And that's the mental state of affair of that lady, my lord. Nothing happens to her, the other person when he does the work. And also another thing, my lord. Your lordship were disposing the writ petition on earlier occasion on 28/3/18 and page number 228. And paid part is 238. Can I take, my lord? 238. is the operative paragraph. 237. Para 20. From here it started the second round, last round started. Further, it is also the proposed position of law that when delinquent employee gives a reply to the inquiry report, that says the reply is to given a due consideration by the disciplinary authority before passing any order of penalty against the delinquent. In the instant case, it is noticed that although the reply given by the petitioner against the show cause notice was shown to have been sent to the members of the Executive Council, but apart from blatant statement in the resolution number 14, that the reply given by the petitioner does not disprove the charges established in the inquiry. No other material has been brought on record to indicate that disciplinary authority has given due consideration to the said reply. From the said point of view, a procedural aberration is found to have found in the method adopted by the respondent authorities in arriving at the order of removal service. Hence, my lord, there are 21. For both the reasons as indicated above, the order of removal from service dated 24/10/16 as a resolution number 14 of the Executive Council of the University meeting held on 24/10/16 are set aside. As the interventions made on the technical aspect, the required procedure has not been followed. It is provided that international justice will be met if the respondent authority, Dibrugarh University, now proceeds against the petitioner from the stage where deviation from the established procedure had taken place. Although Dibrugarh University shall give a consideration to the reply of the petitioner submitted against the show cause notice and arrive at a reasoned conclusion as to why the reply should not be accepted, and thereafter proceed with the requirement of the proviso 32(6) of the ordinance. It is clarified that implication of the order removal being set aside, petitioner stand reinstated such as, my lord. That's what, my lord. In my reply, I have exactly given those witnesses, my lord, evidences in the proceeding. But in the impute resolution by which they've removed me, lordship file, there in one page, my lord, there I can show, my lord, one line they have written, but no decision they have given. Just I'll show to you, lordship, my lord. Take that order, my lord. That will be in page 241. 240 starts. Next page. This is minutes, my lord. This is quite long one, my lord. Lordship will find in these minutes the point I raised in the reply. This is very important, my lord, because he has repeatedly said appreciation, re-appreciation. If you have discussed here the evidences which I have quoted in my petition, my lord, in my reply, then I am barred from raising issue, your lordship, and lordship also possibly cannot reappreciate. My contention is, you have not even appreciated. Where is the question of reappreciation comes? And that's the reason, my lord, the judgment of Honorable Justice Chandrachud and Justice Banerjee is, my lord, I praise that, my lord. Lordship can do it. Even in my learned friend has cited one paragraph, my lord. Paragraph that is in 2020, my lord. Just now he has done it, my lord. 2029 SCC, my lord. Para 26. In para 26, there's a quotation of para 13. Just let me read from here, my lord. The disciplinary authority is the sole judge of facts. 2029 SCC 471. Para probably that 2029 SCC. My lord. 20. There's inside there's the paragraph 30, lordship has got it, my lord. In para 26, probably, most probably. Para 30. Para 26. Thirteen. Yes, my lord. Before paragraph 17, my lord, just above there is a para 13 kind of quotation is there. Before paragraph 27, just above paragraph. Para 27, just above para 27. Para 13. Let us read. Let me read this one, my lord. Disciplinary authority is the sole judge of facts. Where appeal is presented, the appellate authority has the coextensive power to reappreciate the evidence or the nature of punishment. In a disciplinary inquiry, the strict proof of legal evidence and findings on that evidence are not relevant. Adequacy of the evidence or reliability of the evidence cannot be permitted to be canvassed before the court tribunal. In Union of India, this court held that if the conclusion upon consideration of the evidence, that's what I want to say. Upon consideration of the evidence reached by the receiving authority is perverse or suffers from parent error on the face of record or based on no evidence at all, this certiorari could be issued. That's I want to say, my lord, here. Have they touched the evidences? Did not touch. No finding, lord, should be finding the minors of meeting, my lord. So where from the question of evidence comes, my lord, and substantiated by the judgment, my lord, other one I have given, my lord. So lordship was ample power, my lord, to interfere, my lord. Another point, my lord, last point, my lord, I have something lordship. They are repeatedly saying 12% shrinkage. My lord, shrinkage, about 12% shrinkage, my lord. Yes. My lord, when you see in one of the charges, last charges, student shrinkage, it's a huge blunder I have committed as if. In this is one, my lord, affidavit. I just want to draw your attention to lordship, my lord, what happened. I file in RTI saying, so for the other person, lordship is that 278 in 79, two other orders issued by my junior, similar order. He also writes to a shrinkage. I wanted the records of that order, my lord, measurement book, because I've got specific instruction. Till today in the university, nobody has deducted 12% interest, 12% deduction, my lord. So I sought for, kindly see the last page. Kindly see the last page. In serial number 3730, lordship has seen, my lord. These two measurement books contains, my lord, the work undertaken pursuant to that page number 76 to 77, my lord. Lordship will find, if he produces the record, no deduction. Not at all deducted today. Till today, nobody has done it, my lord. In my case, I've been singled out. And this is the affidavit, my lord. When I filed the RTI, they gave me reply, my lord. The record has been sent to the Land Council in Guwahati High Court, my lord. So the record is with me, my lord. That's what I want to show. If we can show these two measurement books, my lord, a lordship find shrinkage. One of the charges will be proved only, not rest. Only one. And for each one, a man of time from service. Other punishments are the availability is there, my lord. But I'm sure, my lord, it is not there. Because my client is 10% sure, my lord. They have not done it, my lord. That's why she has given me this measurement number. In my lord, this is one important fact. In one of the argument was there, my lord, measurement book, my lord, is in the measurement book, it is found something like this. The register, when there is a, I filed 2263 in respect of the same different proceeding, where there is another repetition, earlier repetition I filed 22617. In that repetition, my lord, the register filed affidavit, kindly come to page number 16, my lord. Page number 16. Lordship has got it, page number 16. Paragraph 29.2, Lordship has got it. 1, 2, 3, 4, fifth line. There is, just a second, not in this case. I just want one example. There is no requirement for any field book or label book because the measurement book which is issued in our record. Now they are saying about the field book not maintained. Registrar himself says, my lord, this is not required the field book now. In that earlier affidavit. And one of the part, my lord, not much relevant, but if a lordship consider this, lordship will consider this also. That's why I have shown, my lord. Lordship may keep this, my lord. This is in earlier order litigation. I just shown an example, my lord. How in every point I have been, my lord, dealt with. In this is the way I have been dealt. Field book, it is there in the field book. I have not maintained the field book. Register says is not required in earlier litigation. This is the just one part, my lord. But the main part is application of evidence, other things, my lord. So, my lord, I have in my written submission, my lord, I have, my lord, this is my written argument. Lordship has got the kindly, it was filed on 9/8/22, my lord. Please have a look once, then I'll end up, my lord.
Yes.
My lord, this is, lordship has seen the page marks are there, my lord. Page number 2 also, let's kindly see. This is my whole entire argument why I have made now, my lord. It is there. All the pages are given. And the last page, can you have a look, my lord? Last page. These are the judgments I have given, my lord. So my humble submission, my lord. Kindly take into consideration all these facts, my lord. Kindly see, my lord. If your lordship can help this lady, my lord. Totally cornered by the university. 4th round of litigation. 4th round, my lord. A person really got tired of coming to the court, a lady, now retired. The other day, found she in the Chennai hospital with her husband, my lord. Running to an year and from, and this is what is happening, my lord. Same thing done by another person, nothingness. And I have been, my lord, singled out, and there's a hostile discrimination, my lord. My humble submission, my lord, be pleased to set aside the resolutions and pass necessary order for reinstatement. Since I retired, my lord, what will be, my lord? Some wages, like wages. I've given the judgments, my lord, covering all these points.
Lordship, permit me just to point out two things, my lord, not that much time. The evidence of the witnesses, the defense witness has not been appreciated, has not been referred to. They have been referred to by the inquiry committee. So that, my lord, I have at page 126, they find reference. From page 125 on, my lord. Page 125, 1, 2, 3, 4. Lordship would see from down below 1, 2, 3, 4, 5, 6, 7, 8. 8th line from the down below at page 125. Starts with the word contract is a supply nature of work, question mark, Lordship finds. In our view, even a supply nature of work, the date of commencement and the date of completion of work should be mentioned. In the given case at hand, it is more so required since the period of taken into execution of the work will also suggest the volume of work done during the period and the feasibility to complete such a volume within such a recorded time. It is obvious that within a period of 8 days, the entire work relating to 2 contracts involving 11,592 cubic meters of earth could not have been completed or is practically impossible to complete. On the other hand, there is no material to support the contention of the charged officer that the works took 20 to 30 days for completion, which is belied by the work orders. The evidence of defense witness number 5, Shri Sanjeev Kumar Sharma, on this point lacks credibility being opposed to the evidence of the contractor defense witness number 6. My lord, I will not go too much into this, but what I am trying to say is that the issue is that the evidence is not taken into record is wrong. It has been taken into record. One more thing, if lordship just allows me, at page 127.
Yes.
Because what had happened is the allegation was that the earth was not filled and the bills were paid. All done verbally. Page 127. The fact-finding committee also, lordship finds the second paragraph from the top. The fact-finding committee also observed in its report that the committee visited the site of the earth filling area and observed that the filling of site was not done as per the recorded measurement in the measurement book, and the work is yet to be completed. Even the charged officer in her evidence categorically stated as follows: on physical verification of the site, one may find that the earth filling was not done. However, she explains the following words: this is because contractor Shri Manoj Guhai did cut and remove the earth from the site and took it to fill the plinth in the building. She again says that she was not aware of this fact until the initiation of the inquiry by the three-member fact-finding committee. On the other hand, her witness Manoj Guhai categorically stated that he had orally informed the university engineer that he would remove the earth from the adjacent vacant areas to fill up the plinth in the hostel buildings. The evidence of Shri Manoj Guhai that he cut and removed the earth from the site to fill up the plinth areas of the building remains unsubstantiated. Rather, he contradicts the charged officer on the point of her knowledge in this regard. It has come on record that the inquiry was initiated. The contract Manoj Guhai collected loose earth from the outside and dumped it on the disputed site for the purpose of filling the said site. This only leads to the inference that the whole matter came to the knowledge of the university authority. The charge officer tried to fill up the area with the help of Shri Manoj Guhai, the contractor whom the charge officer has favored with the work order. From that view, the defense witness Manoj Guhai is an affected witness. We have not neglected the evidence of any of the witnesses. The resolutions of a executive council will not record, my lord, cannot be expected to record the argument, each and every statement made in that meeting, my lord. Our each word expressed in this honorable court, my lord, is not recorded in order. The relevant portions are. And when it comes, my lord, to the court of law, my lord, finding a flaw in that this statement is not recorded, this sentence is missing. But that is not what happens in a disciplinary proceeding. Those are laymen. And since submissions were made, going to the hospital, retired, tired, that's why I'm saying, well, if it put the general parlance, one cannot expect the executive council to draft out a resolution which will be impeccable in law. One cannot, that will never be the case, my lord. Now, just one more thing I'll just point out, my lord. Page 128, the charge number 8. 9th line from the top. Page 128, 9th line from the top. Starts with the word both with the contracts. The percent 12.5% shrinkage volume involves an lordship finds. 1, 2, 3, 4, 5, 6, 7. 7th line of charge number 8.
Yes.
Starts with the word 12 and a bracket. The 12% shrinkage volume involves an amount of rupees 4,22,412 paisa 48 only for both the contracts. The charge officers categorically admitted that this deduction was not made, and without deducting this amount, the contractor's bills were paid fully and finally, and that because of this failure to deduct the shrinkage amount, an amount of rupees so and so has been paid to the contractors in excess. The defense witness number 5, who passed the bills, has also admitted that he passed the bills without deducting the 12.5% shrinkage volume. Hence, admittedly, the university suffers the loss of so much of money on this count itself. As there was no agreement executed between the contractors, there was no scope to recover the said amount from them by the university. That is only for one, my lord. So overall, my lord, that is why the Honorable Supreme Court has time and again said, one need not go into the evidence, each and every sentence of the evidence to see whether the evidence is sufficient or not. Even that would not be, my lord, required to be seen. What is required to be seen is there something which proves it? The disciplinary authorities jurisdiction to see whether it is, to see to what extent the facts are fit. Okay. No matter the appeal is the only thing which would perhaps, in my humble submission, come to his rescue, my lord. And the affidavit which has now been produced before this honorable court, I do not know, my lord, without bringing it on record or without giving me notice. I've not even got the opportunity to read it now. Otherwise, what I had shown in my affidavit, my lord, what was projected as a lie to the court in hiding the appeal, I showed, my lord, it was not in reply to such a thing. I could have showed something else, but that lordship will not take into account all those documents which are now being produced before this honorable court. And this RTI, yes, my lord, the RTI part, my lord, one interesting thing has been heard. Specifically, I heard, my lord, the petitioner had filed an RTI, and this was what had come up in the RTI. In the matter of Shri Sahid Raza, I do not
Advocate.
know if the petitioner has changed her gender and her name both.
This is petition advocate, my lord.
And paragraph 2, copy of the RTI application of Shri Sahid Raza. It is not the petitioner. The petitioner is not a disabled person, not mentally deranged,
My advocate, my lord. Yes.
to have filed an application by herself. This is not brought on record.
Okay.
So much things cannot be taken on by surprise by this honorable court. I am taken by surprise.
Senior counsel assisted by
DJ Kapil, my lord.
Jacob. Counsel for Procedural,
Zero.
also heard Mr. R. Maginda and Mr.
Yes.
Hearing concluded. Let's move it.
My lord, so blessed your lordship. So much time your lordship is given to us, my lord. Really, I'm so grateful, really, my lord. Hardly we get such time, my lord. Another thing, my lord, lordship give us free hand, my lord. I've noticed. Always lordship give us free hand. My Kapil was telling me. So it will be comfortable for us also to place, my lord. Result immaterial, my lord. Whether if we win, we lose, we'll go out with a smile from this court, my lord.
Item 1, my lord. We are seeking extension of time to file appeal. Your lordship granted 15 days, my lord. We could not file appeal within 15 days.
Where were you?
My lord,
I fixed it on 23rd.
Pending as pending as
Who's the other side?
other side, my lord, standing council, my lord, of education, elementary, my lord.
You are the.
Let it be on.
You can dispose of by a short
Yes,
or.
lordship. Departmental appeal divorce.
I don't understand when you're giving so many liberties, you don't take the
Ah.
chance.
They need to also.
Your lordship dispose of the writ petition granting liberty as, my lord, to file appeal, departmental appeal, my lord, within 15 days.
Yeah, Mr. R. Ali.
Lordship.
Heard R. Ali, Leonard counsel for the applicant. Also heard Mr. R. Maginda, Leonard standing counsel.
Elementary.
Elementary. Stop. Para. The applicant as with petitioner had filed WBC number 3097 of 2022 before this court, challenging the provincialization of the services of the respondent number 7,
Lordship.
respondent number 7 in the writ petition as assistant teacher within brackets social studies of 3 number. Is it Bandara?
Bandaraman.
Bandara AB Madras in the district of Bongaigaon. Stop. After hearing parties, the WBC number 3097 of 2022 was disposed of on 6/2/2023. And the operative portion reads as under page 11, A to A. Stop. The applicant, by way of the present interlocutory, is praying for extension of 15 days time to file the appeal before the state level scrutiny committee as directed by this court in the order dated 6/2/2023, passed in WBC number 3097/2022. On the ground that due to ill health, the applicant could not file the appeal. Stop. You have any objection? Majumdar? After hearing the after hearing the learned counsel for the parties, comma, this application is accordingly disposed of, extending the period of appeal for extending the period of appeal by 15 days with effect from today. Stop. Draft, comma, the state level scrutiny committee on receipt of the appeal shall dispose of the same in terms of the order dated 6/2/2023, passed in WBC 3097/2022. I is accordingly disposed of.
Deeply applied.